Yes. Give. Please give.
My Lord, inclusion in the list as per observation of the Chief Justice dated 21st of April.
Lordship, upgradation, Your Lordship. Lordship, item number 136.
Wait. Upgradations, please wait. Let inclusions be taken up. Inclusions.
My Lord, may I put it in the chat box?
On original side, madam, my Lord, non-prosecution. My Lord, non-prosecution.
Yes, please give.
Lordship, may we permit to mention one matter?
Original side,
Because
madam,
Please wait.
original side.
My Lord, for inclusion, may I put it in the chat box?
Non-prosecution, please give. Non-prosecution.
non-prosecution.
Please pass on the slips from behind. My Lord, I'm mentioning, my Lord, two matter, my Lord. My Lord, today one matter is fixed, my Lord. One similar matter is fixed, my Lord, as item number 10, my Lord. My Lord, kindly, my Lord, take this matter also, my Lord, along with that matter, my Lord. Item number 10, my Lord. My Lord, this is regarding, my Lord, the... Please wait, let the matters be taken up, then I'll see what is to be done. My Lord, Mr. Bhattacharya is leading us, my Lord. Just wait, let the matter be called on. My Lord, may I hand over the slip, my Lord? No.
For application.
Which item is it?
Item 973, Your Lordship. The urgency in the matter is, Your Lordship, the respondents are trying to blacklist the petitioner arbitrarily. We are in the business of deploying remote sensing devices in the districts of West Bengal, Your Lordship. They are in contract with West Bengal Pollution Control Board. They're trying to blacklist the petitioner.
What do you mean to say that trying to blacklist?
Your Lordship, so the petitioner has already deployed 2 machines in Kolkata.
But as on now, no steps have been taken.
They have already terminated the contract arbitrarily.
Termination is different.
I understand, Your Lordship. I'm satisfied. If Your Lordship can kindly take this for upgradation matter.
No, please wait. Yes.
I'm mentioning item 474 of the monthly list for upgradation.
Why?
The petitioner is the owner of a residential building.
Tell me if it is really urgent, then only. Otherwise, please do not mention. You see the crowd over here.
It is urgent.
Why? What is the urgency?
The urgency is this: the petitioner is not getting the admitted amount to be paid by the electricity distribution company.
Non-payment of admitted amount, no urgency. Yes.
Item number monthly list 1161, my Lord.
Urgency.
Urgency, my Lord. Petitioner is a scheme for rehabilitation and return back for their normal life. Mouse is squared, my Lord. Member and non-available section offense bail. Thereafter released for bail.
No, nothing.
My Lord.
Yes.
Applied for
2 of monthly list.
appointment, my Lord.
No.
But, this is
Any
the
job.
upgradation matter for urgencies that the petitioner is continuing with a shop on the remote area, but the license is not given in favor of petitioner.
Why?
But it was given in favor of respondent.
Yes.
In favor of respondent.
License has been given in favor of respondent. You want to challenge that?
Yes, ma'am.
No, sorry.
My Lord,
Yes.
may be permitted to mention item number 1185. My Lord, the petitioner actually takes vehicles for the sale authorities, children who are going for their school. Now, my Lord, the school vans which are given, they are being overburdened by those children only. The sale authority, we are asking for the list to them. My Lord,
No, sorry. Yes.
may I be permitted to mention, my Lord, item number 1623, my Lord. My Lord, I purchased stamp paper, my Lord, which is found
Fake.
my Lord.
Yes. When did you purchase it?
My Lord, I purchased 2021, my Lord.
21. We are in 25. No urgency. Yes.
Lord, may I be permitted to mention one matter, my Lord?
It's owner of the land, but petitioner is not being granted by common else. Being granted by
Sorry. Yes.
Already May 1922, Your Lordship, the district administrator had passed an order of shifting Calcutta bus station to central bus station, Your Lordship. This was also upholded by in a writ petition, Your Lordship. However, publication is needed to make the transfer happen, Your Lordship. But 3 years have passed and multiple representation has been given. The public.
You want the transfer of the bus stand?
Bus stand.
Go to the public litigation bench. Yes.
My lord, may I be permitted to mention one
Petitioner
matter,
is a
my lord?
successful bidder, and there is a gross annually in the BOQ, bill of quantities. In spite of giving the intimation to the authorities, this BOQ has not rectified, and that's why petitioner has suffered loss. And only 10% payment has been disbursed in favor of the petitioner.
You want the 90%, nothing now. Yes.
My lord, is extreme.
Executive Engineer PWD Bakura Division withheld the payment.
No withheld payment, nothing doing. No, please wait.
My lord, kindly. My lord, entire business operation has been stopped. They could not afford their family. My lord, kindly
Wait.
take this matter, my lord.
Yes.
The petitioner is a college going student, online shop owner with fraudulently got managed a marriage certificate with this petitioner. The learned civil judge, Junior Division, Paschim Medinipur already passed an order on 27th of April 2024.
What do you want here?
My lord, the registered officer is not removing the marriage certificate from the portal, even after 1 year of lapse of 1 year.
Marriage certificate from the portal.
Yes.
Your marriage has been nullified
Yes,
by
null
the
and
court
void.
below.
Yes.
Nothing doing now.
My lord,
Yes.
item number 1329, my lord, the widow of the petitioner, widow is the, her husband died. He was in the merchant navy. I am praying for the disbursement of the death benefit. And he has no.
Widow is the petitioner over here.
My lord, the wife. Wife.
The widow, the person concerned has expired.
My lord.
She wants her terminal benefits.
She has no other means of income.
And who is to give the terminal benefits? Merchant Navy, you say? Who is the authority?
But this is a residuary matter. Yes, merchant.
Who is the authority to disburse the benefit? You do not know. Inquire and come back.
Lord, may I be permitted to mention one matter, my lord?
The petitioner has not been paid for over many years regarding the bank payment.
Bank payment for what?
So, Lordship, the payment has not been made. And in order.
Why? Why? You have done some work?
Yes, Your Lordship.
Payment has not been made. Please wait.
Self-help group, their last bill has not been paid. This is the first time I am coming before my lord. On earlier 2 occasions, my lord, the direction and thereafter bill paid. This is the third time their bill has.
Bill, payment of bill. Payment of bill. I am refusing everybody.
Lord, may I be permitted to mention one matter, my lord?
Paid the license fees, but in spite of that, they have not used side choice. They have not given the permission. That's why I'm coming.
Which license fee?
Liquor shop.
Liquor shop.
Yes. I paid.
Liquor shop, no license now. No, yes. No, what?
1156.
Yes.
The poor cultivator. This land has been acquired by the HPC.
Right.
Without providing any compensation. This land is the only source of it.
Why are you here before the residuary bench? It should go before the land bench, acquisition matter. Which is the item? I'll release it. Which is the item? 1156 released. Land matter. For want of determination. Yes.
725 challenging the decision-making process of the tender matter, my lord. The work order is immediately to be issued. The particular L1 candidate doesn't have the labor license. In spite of that, the authority has already, my lord, made the particular incumbent as a L1, my lord. That is the substance of the requisition, my lord.
The work order has been issued.
No, my lord.
When? And when was the auction or the tender take place? When did it? 25 is continuing. When? April 25. What is the item? 1725. Give notice to the other side. Thursday it will appear. 1725.
No, with regard to item number 2125, my lord, I'm praying for upgradation.
May I have your lordship's kind leave to mention a matter, your lordship? It's a construction contract. Within 24 hours, my reply not considered, contract terminated. Within the next 24 hours, tender floated. Today, your lordship, the tender has been open for bidding, and any day the contract may be awarded.
And you have not been allowed to
Your
participate?
lordship, no, because my contract, over 70 to 80% of the work has been completed. My contract was unreasonably terminated within 24 hours of my reply.
Right.
Now, your lordship, we had urgently moved it before the vacation bench. The vacation bench had allowed my mentioning, but it could not be taken up. Your lordship will kindly allow for urgent listing of the matter. Any day, your lordship might take it up, because the contract may be awarded on any day.
Is the matter there in the list? No.
No, your lordship, it was before the vacation bench.
Where is the, what is the
handed
number?
it over WPA number 12308 of 25. WPA 12308
12308.
of 2025.
Thursday it will appear, serve notice.
Great for your lordship.
Matter item number 1021 of that.
Urgency.
Matter relating to pension scheme. Petitioner was waiting.
Sorry, nothing. Please wait.
Suddenly, my lord, petitioner is
Please wait. Yes. Yes.
Edward Peter and so working 22 years with medical college. In spite of successful bidding, he is not work order is not
Being issued. Yes, why? You do not know.
And no, my lord, and work order is issued against any third party without any circular.
So has been issued. Please wait. My lord, I'm mentioning, my lord, two matter, my lord, 1163 and 1197. My lord, these two matters is relating to bank freeze, my lord. Petitioner are the businessman, my lord, they cannot. Please wait. My lord, kindly, my lord, there is some urgency, my lord.
My purchase deed has been cancelled. It has been cancelled on the basis of the Solenama in the trial court by the purchase and vendor. And on the basis of.
Please let her go out at least. Don't rush. Yes.
Purchase deed has been cancelled on the basis of the Solenama filed.
Yes.
Then the vendor and on the basis of the cancellation, my entire the preemption case has been goes. But the recording in the registration of his demand and on the basis of the recording, they try to third party interest. It is very important.
It cannot be.
I have 22 lakhs. I have already deposited 22 lakhs. I have if the third party is interested.
If the Solenama petition is allowed and the deed is set aside, then the registration automatically goes. What remains?
So that's why I am coming. My preemption has got, but on the basis of the registration, third party interest now to try to creating.
Oh, civil papers. No, I'm not upgrading. I'm not upgrading. Yes.
Item number 417. Here, the petitioner vocational training has been shut down by the hooligans. And the
by the hooligans?
Yes, your lord.
Vocational training?
Yes, your
Who are the hooligans and where are you studying?
Yes, your lordship. The respondent authorities.
Who is the respondent authority?
I don't know the lordship.
Yes.
My lord, I made an application for issuance of MMR license. My lord. If it is issued, then my lord, my application will be in successful.
MMR license will be issued. It will be issued in due course.
Issued in favor of any others, my lord. Then I have no case. My application will be in success. I made an application.
What is the item number?
My lord, 1459.
1459. Day after tomorrow, serve notice.
Two items 1683. We have completed the work by the irrigation department, but till today no payment has.
The payment I'm not upgrading. None. I understand. Yes, next.
Madam, may I be permitted to mention one matter, my lord? 2125, my lord.
Swatantra Sainik pension? Swatantra Sainik pension? I have refused. Just now I have refused.
The father died.
Yes.
Petitioner is the unmarried daughter.
Your father was a freedom fighter and you go on relying upon that. Unmarried daughter. Sorry. I am not upgrading. I have refused one. Yes.
1567 of your lordship is today. Alert petitioner before your lordship is a senior citizen suffering by various ailments. Alert son and daughter-in-law, who is the only close relative, is staying in the Australia. Petitioner applied for the passport. Passport was granted by the competent authority. Now applying for the visa. Tourist visa for the only purpose of treatment. Now unnecessary that tourist.
Whose treatment?
Self petitioner's herself treatment. Petitioner wish to go to Australia.
Why? Treatment is not available in India?
No, for better treatment. No,
better treatment?
Nobody is there. Nobody is there. Petitioner only son and daughter-in-law is in Australia for working purpose. Now petitioner applied in the month of December for the passport. Passport was given. Now visa is withheld. Only that matter. Only that purpose.
Visa is withheld must be for some reason.
There is, my lord, there is no unnecessary withholding. Only observing the web page is withholding for repeated period, for a long period. But that is the difficulties, my lord. I have mentioned your lordship before the vacation.
Yes.
My lord, your lordship told after vacation. My lord,
yes.
It is the life. It is my life.
So why don't you get treatment over here in India?
I am no close relative here, my lord. My only son, I have stated in the repetition, only son and daughter-in-law is staying.
Yes. Let your son and daughter-in-law take care of you. Yes, the court is not upgrading. Yes, please.
Similar matter, but I purchased the property from the bank. Plus the bank without even possession created third party interest and is going to
Under the SARFAESI proceeding?
yes, created coming from service portion.
Yes. Why are you here? You have got the.
I already been purchased the property from the bank.
Yes.
The
The sale is under the SARFAESI.
sale is under the
Then?
service. And subsequently, without giving possession, but the bank is going to create a third party interest. This is a subject matter of this.
I don't think I'll upgrade. Yes.
The financial cheating cyber crime lawsuit 8,75,000. Petitioner has given us so much notice to responding to the ladies, but responding to the still did not take any action.
Action against whom?
ICICI Bank.
Why? What has the bank done?
Also, they cheated lots.
Bank has cheated you. Why? How?
Cyber crime lawsuit.
Bank has made cyber crime.
So, bank
No, sorry, you have to say the urgency. Yes, ma'am.
Regarding the illegal mining that is going on in Birbhum district, my lord, for past 10 years. Now the activities has increased, my lord. I am one of the contractor appointed by the West Bengal Mineral Development Authority. So I cannot carry out the work there, my lord. And also they are asking for DCR, that is duplicate carbon copy. The second time they are asking for the royalty, despite I paid the royalty by e-challan, my lord. Well, I only take the patent champion as item number 1727. Let it be my upgraded.
1727, day after tomorrow, serve notice upon the other side. Slip is not required.
Can to mention 11 identical matters, my lord. Item number 1485 to 1.
Urgency.
Well, urgency is that all the petitioners are the highest bidder of the tender process, my lord, and they have completed the
11 highest bidder. 11 highest bidder.
tender notice, my lord. Individual tender notice, my lord. In the corona period, my lord, there were the tender notice, several tender notice was released by the competent authority to.
Now what has happened?
Thereafter, my lord, they have completed the service, my lord. They have
Payment not made. Please wait. Yes.
My lord, question of bread and butter.
Wait. Yes.
Number 706 of today's list of your lordship list. Your petitioner has taken loan during COVID period where your petitioner has been granted few relief while repaying the loan. But currently State Bank of India is not giving him that relief.
Giving him what?
For repaying the loan.
You took the loan during the COVID period,
Yes.
and now you cannot repay.
I am repaying, but there was some relief granted by the SBI during that period of time. But at this juncture, the SBI is not granting.
Obviously, COVID period benefit cannot be extended now. Nothing doing. Sorry. Yes.
I am mentioning item number 2154 of the monthly list. This is a tender matter, and your lordship had taken it up on 19th May and fixed it for hearing on 21st May. The lordship did not sit on 21st May. Now it has been relegated to the very last item of the monthly list.
Yes. What is the urgency?
Lordship, the urgency, it's a tender matter, and unless the steps are taken to hear out the petitioner, the writ will become infructuous.
No. What is the urgency in the matter?
The urgency is that he is the L1 bidder,
Then
and
what
he
happened?
is being deprived of the work.
Has somebody else been allotted?
Somebody else is this thing. Who is not the L1?
Work order already issued.
Mulchi.
Who is not within 48 hours from the date of uploading the credentials, not he was to make a complaint, he could not complain. He waited till 14 of the financial bills. After the financial bill was.
What is the item number?
2154.
Is it the same number that you 2154 day after tomorrow?
Instead of day after tomorrow, from Friday, and next Friday.
So, why Friday?
Lordship, Mr. Ashok Banerjee is appearing in this matter on
Yes.
behalf of the petitioner.
Right.
So,
Friday
day,
will be-
day after tomorrow is fine with us.
It is difficult with them. Will it be difficult? Very well. 2154 day after tomorrow.
is if there is any other authority, because he'll be for the private party, the main authority
I have served the other response.
serve once again. Yes.
I need to mention, your lordship, I
Deeply
mentioned
obliged.
this matter just before vacation. My lord was kind enough to allow the restoration application. This is with regard to one of our learned friend, junior friend, who has been suspended by the State Bar Council. Your lordship has failed to fix this matter. 8 months has already passed, 2 years out of 2 years. Kindly fix it, my lord.
What is the item number?
This is not appearing because your lordship restored the matter on 8th. Then your lordship
Very
asked
well.
me to come.
Give the number. Give the number. WPA number.
WPA number 25994 of 2024.
25994
of 2024.
Next Monday it will appear. Serve notice upon all the parties.
Much obliged.
May I have my
May I?
May I? What do you want? Restoration. Is the matter there in the list? Have you handed over the slip? Now, all slips for inclusion has been taken. No slips will be taken now. All right. Please wait.
May I have one of time leave to mention one matter, my lord?
Order which is already substantive. The matter has been extended till 30th of June.
30th of June? Today we are on 9th. Why are you mentioning now? Please wait. Extension I'll take up later on. So you 30th of June, the interim order is there. You please come on the 20th of June.
Lordship, may I be allowed to?
In the current matter, the petitioner is a livestock farmer. He applied for a
Petitioner is a
livestock farmer.
Yes.
He applied for a loan in the National Livestock Mission scheme, which is a welfare scheme. But the current bank, despite fulfilling on all the eligibility criteria, the bank is withholding the loan amount. Lordship, even if the loan amount is passed after the breeding season, the petitioner cannot utilize the amount to farm because the breeding seasons are the crucial.
I'm not upgrading. Yes.
Considered person, I have applied for passport. The issue is
You have applied for
passport.
passport.
This is regarding my name, my current name. I was earlier known as something else. Now I'm known as something else. My urgency is that I have a workshop to attend in UK in the next month, and they are not considering my representation.
What is the workshop for?
For farm center activity.
What is the item number?
Item number 560.
560? Thursday. Serve notice upon all the parties. Slip is not required. Yes, sir.
May I be permitted to mention one matter, 2125 for upgradation?
Urgency.
Father was retired primary teacher and he died on 8th December 2024. Running pension payment order deposited some money, about 9 lakhs, without success and certificate released from 10B branch Mandal to under the district of Bankura.
Released in favor of whom? Nominee. Who are you?
I am the legal heir of the son, second son.
Yes. So you sue the nominee.
Without success and certificate.
You sue the nominee. Nominee has the. It is the duty of the nominee to distribute the money. No, sorry. No. Check up the law. No. Yes.
He's going to take the position day after tomorrow. After I got this notice.
Surface proceeding. Yes. Why are you here and not before the tribunal?
My lord, actually, the property which has been mortgaged, they have started submitting another property. That is why I think that this is the better forum, my lord.
This is a better forum? No, sorry, sir. Forum is the only forum is the tribunal. No better and lesser.
We have under for the debt.
Yes, it is not being taken up.
Yes.
That is the reason you are here. Yes, I can understand. But sorry, sir, I am not accepting your prayer. Yes.
Lordship.
No, sorry. Yes.
Your lordship's list, my lord. My lord, the urgency is, my lord, I have been a prey of bank fraud, my lord. My lord, without my notice, my lord, I have not shared any notice or anything, my lord. 60,000 rupees has been defrauded from my account, my lord. I went to the RBI ombudsman, but RBI ombudsman, my lord, has
I'm not upgrading. Sorry.
Lordship, may I be allowed to?
I'm not upgrading. Yes.
2125 for upgradation for release, my lord.
Your lordship, I have invested a huge amount of money, approximately 93 lakhs of rupees, in purchasing a particular property in the SRTC auction proceedings. Lordship, the sale certificate was issued in my favor in the year 2023 December. The the title deed hasn't been executed as on date, Your Lordship.
What is the reason?
Lordship, the bank has not provided any reason to us, Lordship.
Yes. So you have filed a writ petition
Yes, Your Lordship.
and it will be taken up. Sorry. Yes.
Item number 1475 and 1593, my lord, Supreme Court has recently passed an order that any Rohingya Muslim who has completed their sentencing and has spent 3 years after that is eligible for bail, my lord. I'm granting for similar
Eligible
relief.
for bail?
Yes, your lord.
So why are you here? Go before the bail bench.
My lord, they have already completed their sentencing. The writ petition is pending. There is one of the prayer in the writ petition is that bail.
But you can approach for bail.
Yes,
Approach.
my lord, in the writ court only has, my lord, passed that.
No, it's all right. But then you approach before the bail court. Why are you here in the writ? Yes.
The item number is 1525 of the monthly.
Urgency.
My Lordship, the petitioner was entitled to a construction of ICDS center, and the construction work was completed at the
Payment has not been made.
Yes, my Lordship.
Nothing doing.
My Lordship,
Please wait.
Lordship, my issue has already been settled. I am praying for withdrawal of the writ petition.
Item number
889.
889 for non-prosecution. It will appear in the list. Please.
With regard to item number
Lordship, we have
2125, I'm
mentioned
praying
a
for
matter.
only
This
release.
is contempt application for inclusion.
Why are you mentioning? I have already accepted slips. I will not accept slip now.
Malas, I need to mention, Malad, the airport authorities, irrespective of issuing a no objection certificate, after which our residency has been constructed and the residents are residing, they are now issuing a notice for demolition of the building.
Yes.
In 2014, they had issued the no objection certificate. Everything has been done. Now they are issuing this notice that they are going to demolish.
Because of the height
Yes, but
limitations.
everything was done. Everything, all clearance was given by the airport.
All right, but then has anything been done now?
Anytime, Malad, in the month of February 2025 itself, they had given the notice, Malad, and anytime
And it
they
is still there in the list.
Yes,
It's
ma'am.
there in the list.
1445, my lord.
Let
my
it
lord.
remain. Yes.
Very unfortunate case, my lord. The husband of the petitioner was admitted to a hospital, my lord, with a case of appendicitis. That, my lord, turned to to his death, my lord, owing to, my lord, incorrect stitching being done by the doctors. A complaint, my lord, has been filed before the West Bengal Medical Council. My lord, repeated follow has been made. Nothing done till date, my lord. A very sensitive case, my lord.
It is not sensitive.
Nothing has been
Then,
done.
please wait. I'm not upgrading. Yes.
But I'm praying for only release, my Lord.
With regard to unauthorized construction.
Unauthorized construction. Where?
Free of unauthorized construction. My dwelling house standing on the right land is going to be demolished by the SDO.
By the SDO?
SDO contact, my lord. That is the whole trouble.
Why don't you go before the panchayat bench?
By virtue of that, unauthorized
No, go before the panchayat bench. Which is the item I'll release?
The PWD land, my lord. PWD land.
PWD land. What is the item?
768, my lord.
768. Thursday. Serve notice.
My lord, may I mention item number 157?
Urgency.
My lord, my passport has been impounded by the passport authority on the ground of inadequate police verification. My lord, twice I approached the passport authority for re-verification, but no steps were taken. Thereafter, I made representation for.
What do you do?
My lord, I am a contractual labor, acting as a casual labor in Saudi Arabia, my lord. I have at present I am jobless.
Try to find out work in India. Don't go to Saudi Arab. Yes.
My lord, kindly, my lord,
No, nothing doing now. Yes. For what? Modification.
Well, I preferred an appeal. Division 1 division has said that unless this paragraph should be rectified, otherwise your appeal cannot.
What was the matter about? Transfer?
Transfer, and the submission has been recorded. Make an application because the submission was only recorded. But I preferred an appeal. Commissioner said that this is your submission.
Yes.
To be rectified, but this submission was not made on behalf of.
All orders are given in open court. If you say that it was wrongly recorded, you ought to have pointed out then and there. Very well, I'll take it up. Give. Application for modification will be taken up. Yes. No, please wait. Yes.
Urgency. I'm appearing online. Item number 1322. I am the nominee.
To cancel. But he just wants to meet his daughter once. Wants to travel to the US.
Let the daughter come over here. Nothing doing. Yes.
Item number 966.
My lord, item number 1242, my lord.
I have already submitted my
Payment of unclaimed dividend. But dividend will be received by you. Yes, nobody has claimed it. Now, where is the difficulty? No, you are not proper on facts. Yes.
My lord, item number 1242, my lord, for upgradation, my lord.
Why? Did you approach the registrar? Here, the registrar general. Now, if the lower court certified copies are not given and everybody approaches the high court, then the high court will stand still. No matters can be taken up. Only for obtaining a certified copy, you are here with a writ petition. Please follow up. I am not upgrading. Yes. Go before the tribunal. Yes. No, but then inclusions of slips have been handed over. Well, please wait. Lots of slips handed over. Yes.
My lord, item number 1242, my lord.
Why? What is the
resolution which is contrary to that is why I litigation. Because they are setting up some construction of common place, which I have also mentioned, and also one of my group is also political.
What is the item number? 1706. Next Monday it will appear. Please serve notice upon all the parties. Yes. Yes. No, financial bid open. What can be done?
Because other parties are involved with that, I have already invested the money in some amount.
No, nothing doing.
May I have,
No, nothing doing. Yes.
may I have my lordship?
Petitioner is a senior citizen.
Huh.
And final petitioner is the account holder of a bank along with other private respondent. The private respondents are being fabric body and withdrawing the money. I made an application to the concerned bank to stop the operation of the account. Same is not.
No, they are also the account holders.
My lord.
Yes, then.
Without my consent.
No, it's private dispute. Not upgrading. Yes.
Out of the premises, the respondent bank is neither paying the rent, nor are they paying the taxes, neither are they handing over the possession, and KMC is demanding the property taxes from us.
Yes.
Paying for us.
No.
May I have my lordship's kind leave to mention original side matter, my lords?
Oh, original side, wait.
Your lordship, petitioner is a lady. She has applied for passport, and there is a dispute in the date of birth, and she's having a marriage in the month of December outside India.
Let the husband come here and get married. Yes.
My lord, Senior Citizen Act, my lord, during pendency of this writ petition, my lord, the parents have been ousted by the son and daughter-in-law, my lord. This is the urgency, my lord.
Then what is the tribunal doing?
Tribunal, I have exhausted, but the tribunal is not taking up the matter because the post of the SDU is vacant, my lord. That's why I am coming for the writ petition during pendency of this.
What is the item number?
400, item number 400, page 190.
Monday it will appear. Serve notice upon all the parties.
May I be permitted to mention with regard to item number 1471, my lord, this is a tender matter, my lord. The petitioner participating in the tender process, All India Radio, Kolkata, Akashvani, my lord, they have displayed the status of the petitioner is disqualified since they have participated in the year 2017-18 and secured a contract. For this reason, my lord, they have disqualified, my lord. And my lord, the petitioner cannot participate in the tender process. My lord.
The process is over.
Process is over.
Nothing doing. Sorry. No, sorry. Yes.
Because my lord, the petition made because procedure time was not taken up. Out of contract during the course, postgraduate course. Now, without adhering to the merit list, 3 of the past matters picked up. I'm posted in a place which was not chosen by us in terms of merit. That's why our case should be done in terms of merit. I'll take it.
Suppose it is not upgraded, then what will happen now?
The post will be filled up. I have chosen the post I have chosen will be filled up.
This is transfer.
No. But during our post, we have executed a bond. That
Yes.
will serve for 3 years for the state. But for these 3 years, there is a counseling in terms of merit.
All right.
The council have chosen a particular place.
Yes.
Now that place has been not given to us. Only 3 of us was leading the case during the Arjuna incident, the protest. Now only 3 of us has been picked up. Otherwise, all 200 has been given in terms of their merit. And
What is the item number?
I have handed over the slate.
All right. What is the number?
12310 and 123.
12310 and
12309.
12309. Thursday, serve notice upon all parties.
Well, item number 1242, my lord.
Well, item.
From HITCO?
Yes, sir.
But then you paid money to somebody else. That person. No, I'm not upgrading.
Well, 2125, I'm only praying for release, my lord.
Whose father's signature? Who is going to compete? The son? What is his age? What is the item number? Item number. What is the case number? One, 2, 4, 6, 8, 25. Next Monday it will appear. Serve notice upon all parties. Slip is not required. Yes. Sir, I just now refused your prayer. Please do not repeat. I am not here to give you advice. Yes.
Long back pressure was there to sell the land to some potential persons. I denied. That's why they have constructed temporary.
They means
Politically influential local persons.
Why are you here before the writ court?
The land is the surrounding land is of PW.
Yes. Why? Against PWD civil rights, you cannot sue. Yes.
Directed by the private respondents in connivance with the PFD, they are silent. I have repeatedly printed that.
Please wait. Yes, madam. Yes. Urgency. For release, why?
Pertaining group 5.
Item number? Item number?
1751.
1751. Are you the advocate on record? You are the junior, and the matter relates to which group?
It relates to group 9, but it's group 5, but it hasn't group 5.
Very well. Group 5 release.
Only certificate of Indian access has been left for me.
Sorry, sir. Yes.
Calcutta compensation matter. The
Right.
petitioner is facing extreme poverty. She has
Item number?
item number 6646 of item number is 1391 today's list. And the matter,
1391.
yes, in the monthly
Next Monday.
This is a tender matter which was mentioned on 20th May. Matter was fixed on 22nd May.
The matter relates to?
Tender matter.
Yes.
Lordship, the matter could not be taken on 22nd May. The moment the matter could not be taken, a work order was issued in favor of the other persons, contesting persons.
Yes.
Lordship, we tried moving it during the vacation, but they mentioned and they said that the work order has been issued, so it wasn't taken up. Lordship,
Now what can be done now? The position is the same. Work order has been issued.
Lordship, even though the work order has been issued, I believe the work has not yet started.
Yes.
Lordship will kindly fix it on any day, hear it. It's a completely illegal act. IOCL has issued these work orders bereft of laws, contrary to laws. Your Lordship will kindly hear
What
it for
is
2 minutes.
the number? Is it there in the list?
Yes, my lord, it's 1721.
1721. Next Monday it will appear. Are you there for the private party?
Private respondent.
Then IOCL has to be intimated.
Yes, ma'am.
Put on notice.
Milord, item number 917, Milord.
Urgency.
Milord, urgency is that, Milord, Anganwadi health card was examined they were taken written interview. Thereafter, oral interview was taken up. Currently, my lord, the panel has been cancelled. Proceedings has been cancelled.
Anganwadi, go to group 5.
Yes,
If it is service matter, go to group 6. Why before the residuary bench?
my lord, the Anganwadi helper.
So what? You go before group 5 bench. Which is the item number?
Item number, my lord, 917, my lord.
917, I'm releasing it. 917, release.
Civil obliged, my lord.
Give your name.
Yes.
My lord,
Yes.
to mention, my lord, I have the petitioner is the
Urgency.
My lord,
Very precisely, yes.
the petitioner is the owner of the flat, my lord, a flat. The previous owner took the loan from the against that flat. The bank served the possession notice on behalf of the petitioner.
What are you not moving the tribunal?
Yeah, the tribunal is not working, my lord, at that time.
Now it is working. Please go.
No, my lord, please.
Yes.
Item number 1749 of your lordship.
Urgency.
Well, this is a matter petitioner is an accused. Well, I know
Petitioner is an
accused in a case. Well, I know that the public prosecutor or investigating agency, the petitioner cannot choose. Well, but the advocate who was initially representing the de facto complaint changes his stance, gets appointed as a public prosecutor. He engages his petitioner as to represent the de facto complaint. Withholding document. The judge is observing that such anomalies. My lord, we made a representation with legal remembrance, incorporating all the facts, including order sheets and everything. Asking
Why don't you approach the learned court below?
well, court below doesn't have the power. It has the power with the legal remembrance.
Yes, that is all right, but at
Because, my
least
lord,
the court
my lord,
can
because-
take
because,
give some
my lord,
observations.
Because my lord, those things had to be evaluated by legal remembrance cell. The court cannot take a decision who will the public prosecutor will be.
It is not a matter of taking decision. This is absolutely professional practice
Right, my lord.
is not being followed properly.
In the record, my lord, his name is being struck from the Vakalatnama. My lord, your lordship will just hear me once. My lord, I will give notice any.
What is the item number?
1749, your lordship.
1749?
Yes, sir.
Next Monday. Serve notice upon everybody. And did you make the learned advocate a party?
My lord, no, legal remembrance. I think I have been party, my lord.
Because you are making all allegations against an advocate and without making him a party, the writ cannot proceed.
Advocate, I have not made. I have made party legal remembrance considering my representation. There I have incorporated order sheet and everything has been done.
I do not know. I have to check.
Well,
Come.
Setting up of a illegal poultry farm in order to put maximum prejudice to the petitioner. These things are being going on in an overnight pattern. The matter is brought to the notice of the concerned authorities. They are simply sitting tight over the issue.
How many birds are there?
There are many. Every day.
Many means how many?
These are the rise.
How many?
More than 100.
Sorry, I'm not including. Neither upgrading. Yes.
Matter petitioner has sought for investigation into financial irregularity of Indian Society for Chemical Engineers. The representation was forwarded to the concerned authorities as per Section 23 of the West Bengal Society Registration Act, but no action has been taken till date.
You want consideration of the representation?
I want consideration, yes, but I also want the investigation to take place into financial irregularities of a society.
Yes. What is item number?
494, my lord.
494. Next Monday it will appear. Please serve notice upon all the parties.
Lordship, contempt application for inclusion.
I have taken up all clips for inclusions. Right now, nothing doing. No. Next month.
For correction of appearance in that Porombrata Chattopadhyay matter, your lordship, it was taken up on the 19th. Only one matter was taken up, and all the same matters, the name of the state advocate has been incorporated for that item number 38 matter.
When is the matter returnable?
Lordship, next month.
Next month. I can do it next month also.
Your lordship, I have prepared a list of all the advocates who are appearing for all the matters. This is a complete list.
Let it be the complete list next month when it is taken up. Then hand over this list.
Item number 2117 of your lordship's list.
Urgency.
This is an assigned matter, my lord. Your lordship has heard it once, my lord. But the only urgency is that, my lord, the ED has seized the gold items, my lord, worth, my lord, 15 crores, my lord.
Item number.
My lord, 2117. 2117, yes.
2117 next Monday.
Yes, my lord.
Serve notice upon all parties.
My lord, item number 136, my lord, I am an intending buyer. With consultation with the original borrower and the bank, I have paid 15 lakhs on January 2024, and subsequently in the month of March 2025, I came to know that the property has been sold to someone else.
Yes.
My 15 lakhs is still with the bank.
Yes. I'm not upgrading.
My lord, I have
Yes.
challenged you. I have challenged my lookout circular, my lord. On basis of that lookout circular, my lord, I am not getting my lord passport and visa. I have job offers outside India. Now the difficulty is that, my lord, I am relying upon the judgment of Bombay High Court as well as our High Court, my lord, where, my lord, these lookout circulars were declared as ultra vires. That the authority cannot issue this lookout circulars.
In the same matter?
No, in other matters. So, my lord, on the basis of that, my lord, I have to inform my future employer by June, that end of June, that whether I can travel outside India or not. So for that,
Right now you stay in India. Later on, I'll see.
my lord, kindly consider, my lord.
No, nothing. Yes.
That I have moved the matter, my lord, but due to the positive of the client, it has not been taken now. My lord, what happened? Without issuing the 13-2 notice, my property has been seized. And as the tribunal was not functioning.
Now it is functioning. Please go. No, sorry. Please. Please go. It is functioning now.
Let an order be passed. I will approach before the tribunal, my lord, because due to the tendency of this petition, the tribunal will not take up the matter, my lord.
Give the number.
My lord, it's not in the list.
Yes, give the number. WPA
12167 of 2025, my lord.
12167
Of 2025.
Day after tomorrow. Day after tomorrow. Serve notice upon your other side.
Our enlisted deed writer of ADSR Moina has exchanged the property with the petitioner and conveyed the property deceitfully, availing the position of deed writer and
sorry, I'm not upgrading.
Madam.
I have not been able to follow. I'm not upgrading. Yes, madam. No, it's already 1 hour. Nothing doing.
This is a petition seeking medical assistance for the petitioner's wife, Lordship. She is suffering from mental illness and she is harmful to herself as well as her family. Which
item number
1928.
Next Monday it will appear. Please serve notice. No inclusions have taken up all.
Lordship, item number 908 of the monthly list. Lordship, the husband of the petitioner is an Indian Army. Lordship. There is a provision that if the Indian Army stop maintaining her country, there is a provision the authority can pay the maintenance directly from the deducting from the salary of the employee. Lordship, the petitioner has applied for an authority granted. Lordship. All formalities have been completed, but it is waiting for disbursement. It is not disbursement.
Please wait. Nothing doing.
Petitioner.
Daughters, there are 2 daughters. One have completed.
You could have obtained this order from the learned court below, right?
Anything to pursue the court below, Lordship. There is.
You have everything to pursue the High Court.
Lordship, your Lordship can't pass any order.
Sorry.
Petitioner is a senior.
I am not. Yes.
Petitioner is a senior citizen. Her son thrown her out from her own house. She is above 80 years old. SDO already directed to vacate the premises, but they are not vacating the premises. Kindly.
Item number
1678.
Next Monday it will appear. Serve notice upon all the parties.
Madam, matter relates to the disbursement of the insurance money.
Disbursement of
insurance money.
Insurance.
I have done insurance with the Reliance company through the bank. And
I'm not upgrading. No further mentioning. 1 hour has gone.
My lord, item number 1242, my lord, for upgradation, my lord.
Off shop. Yes, it will be closed this week. Why? License has expired. Licensee expired.
The land has been acquired. My lord has directed to produce the acquisition document.
Yes.
Again, order has been passed to close the shop.
Yes. If it has been acquired, you will get compensation.
That is the problem, my lord.
Please wait. If it is closed, come. Yes.
96 my lord. This is we are the farmers. Our crop has been secured by one beamer. That is the farmer story. And it was given direction, if anything found natural calamity, then it will be provided. From the satellite picture, it is showing there is no drought. But the ground report for the BLL is a drought.
Due to this controversy, we are not getting we are at least 600 post farmers are there, my lord. Next drought is going to be coming.
No, every season there will be drought. No.
We are not on that. We are not on the compensation. At least some direction for the next year. For our crops will be secure. It is not for the previous year.
Next year is a long way.
My lord, item number 1242, my lord.
Sorry, I'm not upgrading. Yes, no further mentioning. Please do not mention.
My lord, I was appearing online.
Under section.
I am not hearing any further.
Online mentioning, I'm praying for only release.
Will be shut down, my lord, by the political hooligans, my lord.
Item number 2125, I'm only praying for release, my lord.
2125.
Yes, my lord. This is a hearing matter, my lord. Before vacation, I had mentioned before your lordship. Your lordship has been pleased to direct me to come after vacation by serving notice on the other side. We have done that. But this is the matter relating to gold loan. Now, my lord, the coordinate bench had directed them to file their affidavit in opposition, but it has been nearly 1 year. They have not filed their opposition. Now, my lord, when I go to recover my gold, they are saying that there is no gold.
Why do you want a release?
But this is a hearing matter, my lord.
So,
but the coordinate bench today, my lord, they have taken a lot of hearing matters, my lord. There is a separate bench for hearing matters. But I'm not covering your lordship.
Item 2125.
Yes, my lord. I have some notice on the other side.
Likhunta, learned advocate, for the petitioner, raised for release of the matter. It has been submitted that the petitioner intends to get the matter heard before a coordinate bench.
Hearing bench, my lord.
Having determination. Stop. In view of such submission, let the matter stand released from the list of this bench.
Grateful.
Stop liberty to mention upon notice to all the parties.
Grateful, madam. Grateful.
My lord, item number 1242, my lord.
Yes.
I'm praying for upgradation, my lord.
Why?
My lord, the petitioner has 2 commercial vehicles, my lord. I am paying the regular EMIs only for delaying 7 days for delaying payment of EMI. They have took the possession of the vehicle, my lord.
So what do you want now?
My lord, I want to release the vehicle from their custody.
I
am not upgrading it. Original side
matter, my lords. My lords will remember, my lords, this is that matter where a 5-year-old girl child, my lords, was killed because of was dead, my lords, because of the negligence of the IVF hospital, my lords. My lords took up this matter, my lords, before the vacation, my lords, and passed directions for affidavit. In spite of that period being over and 1.5 months more being over, my lords, they have not yet filed their affidavits. The matter
if
is
to be mentioned, it will appear. Yes. Yes, original side.
I'm so grateful, my lords. To be mentioned tomorrow, my lords.
Please wait. Check up the list. Yes. Yes. Today is the দেখুন তো Oh, আসেনি কালকে দিয়ে দিন tomorrow it will appear self notice. It doesn't matter, tomorrow it can be done.
May I permit to mention a matter for withdrawal? The original side matter, your lord.
Withdrawal, why?
The talks of settlement going on. The talks of settlement going on.
Only talks of settlement. It has not yet been settled.
No.
Then if the settlement fails?
Lordship, my client directed to withdraw the matter.
There is a written communication. Give the item number. Case number. Very well. Call the list, please.
No. Lordship.
Item 1. Yes, please.
My lord had
who is appearing?
G application.
Yes.
Can this be taken up tomorrow along with it?
Tomorrow, very well, tomorrow.
Wait, please, Lordship. My lord, in this case, my lord, pursuant to a notification, my lord, of this honorable court, my lord, with regard to National Crime Reporting Portal, my lord, the petitioner was subjected to a cyber fraud of 49 lakh odd. My lord, as per this honorable court's notification, Lord, can you see the notification once? My lord, this honorable court has notified that in such cases, we have to immediately report it to the cyber cell division, which we have done. And thereafter that the cyber cell division does not need to register an FIR, but it can take steps to recover the money. My lord, accordingly, pursuant to this notification, we had approached the learned court below. Lordship thereafter takes up page number 50. My lord, it was directed that the money which was illegally taken from me was parked at an SBI account situated in Andhra Pradesh. My lord, the learned magistrate, my lord, directed that that money should be immediately restored back to the petitioner.
No, what is to be done now?
Now, my lord, Lordship kindly takes up page 50 once.
Page 50. Who is your
55
other side?
My lord, all are there.
You are for the?
I am for the state. My lord, last occasion I filed the report because there is already an order passed by the Honorable High Court in Andhra Pradesh. There is a restraint order. Now, my lord, not
In
to.
respect of this.
My lord, may kindly see the date of the order which has been passed by the Andhra Pradesh court and the date of this court's order, my lord, by the learned magistrate. If your lordship may kindly takes up page 50 once. Page 50, my lord, of my application.
This is the order of the Andhra Pradesh.
Andhra Pradesh court order is of 24th to 5th of April 2025. And this honorable court's order, this learned magistrate's court order was 18th of February 2025.
Who is the petitioner over here? This
person who is having the bank account of that SBI account in Andhra Pradesh where my money was illegally taken and transferred to.
Money backs.
But this is a complete scam. Your lordship.
1 minute, let
Sorry.
me hear what
Sorry,
it is.
Sorry.
This is the copy of the petition.
Oh, one second.
Yes, sir.
Here the petitioner is the SP Spin.
Yes, sir. It's a proprietorship concern. My lord, your lordship may kindly takes up first and
Wait,
foremost.
state is the party, deputy commissioner, OC.
Yes.
Kushanko Shekhar Chatterjee, respondent number 4. Why have you implicated him as in person?
Yes, because he's a sub-inspector, my lord, who was supposed to do this. He was supposed to carry out the court's order to transfer the money back to me. The sub-inspector, I made him in person.
I cannot get your prayer. There was any direction upon the respondent number 4?
Yes.
Who has passed the direction?
A learned magistrate, pursuant to the notification which
Why are you not there before the magistrate and why are you here before the
I'm
court?
telling your lordship, because the magistrate had indicated to the investigating officer to take steps to restore back the money. If your lordship kindly takes up page 50 once, 50.
State Bank of India, Mumbai. Then the State Bank of here in Kolkata. State Bank of here, Andhra Pradesh.
Yes.
Bank manager of the State Bank of India, Andhra Pradesh.
Yes.
How are you related to the account?
I'm coming to that. Lordship may kindly takes up first and foremost page number 34 of my application first.
Yes.
Well, this is the starting point of my case. Lordship may kindly goes through it once, my lord.
To the officer in charge, Posta police
Yes.
station, you made a complaint in
Saying that
February
49 lakh
2025.
odd rupees was siphoned away from my account by way of a cyber fraud which was taken place. My lord, the prior page, that is page number 33, my lord, is the National Cyber Crime Portal acknowledgement of my complaint, my lord, which this honorable court has given. Now, my lord, accordingly, we had made an application before the learned magistrate. If your lordship may kindly takes up first page number 49. The investigating officer gives a report that the account which the money has been siphoned off is parked in an account in Andhra Pradesh. Accordingly, my lord, the learned magistrate orders at page number 50 that this money has to be restored back to the petitioner. Lordship sees 18 to 25 order, which is continuation type portion. My lord, if you can place it for your lordship.
nodal officer slash branch manager of State Bank of India, IFSC number so-and-so, is directed to transfer 4394,230 from the account number so-and-so to the account of the petitioner Pradeep Kumar Khenka, proprietor of Spintex, account number so-and-so of Punjab and so-and-so. Petitioner is directed to submit a Zimmanama bond of 4394,230 with the condition to produce the sum before this court or any other court of law as and when directed at its own cost and risk. My lord, thereafter that, my lord, repeated prayers were made. Your lordship may subsequently take up page number 51. Once again, my lord.
1 minute, 51.
Yes, ma'am.
Are you, what is the last line? Wherein it has been submitted that continued?
My lord, 51, my lord, your lordship.
Page 50, the last line, 17th March 2025's order.
Yes.
Received one report, the last two lines
Yes,
of
yes,
IO forwarded by such and such, wherein it is submitted that.
Wherein it is submitted that
that
IO has prayed for necessary order.
No, it cannot run in that way.
That is the pagination. If your lordship sees it's a continuation of 17.320.
Yes, but the continuation is not
submitted
proper.
that IO has prayed. No, that is the your lordship see wherein it is submitted that IO has prayed for necessary order to be passed upon the concerned nodal officer branch manager to retain the entire hold amount to the petitioner's bank account. Petitioner Pradeep Kumar Khenka is absent on call. My lord has seen it. It's a continuation of that. My lord, thereafter that continuation, report is received today. From the perusal of the report, it appears that the IO of this case duly communicated the order dated 18/2/25 to the nodal officer branch manager of State Bank of India, so-and-so. But he failed to comply with such order. Here in this court, it is further directing the nodal officer branch manager State Bank of India, so-and-so, nodal officer or branch manager to return the entire hold account of so-and-so from the bank amount of so-and-so State Bank of India to the petitioner's bank account, Punjab and Sindh Court, having account number so-and-so, and further delay to submit a report on 27th. But this is the stage at which the case is there. Now, thereafter that, chapter 27, but this is the state at which the case was. Now, my lord, we had approached this honorable court. Now, on the last occasion, they produce an order that the person who has siphoned away this money has approached the Andhra Pradesh High Court.
What happened before the Andhra Pradesh High Court on 30th of April?
That, my lord,
you do not know.
But if your lordship kindly see once.
Yes.
But kindly see the facts which he stated.
Was the learned magistrate apprised of the order passed by the High Court of Andhra Pradesh?
But subsequently, it has been apprised by them.
All right.
But
yes.
kindly see once. But kindly see the entire report. But permit me to read because it is necessary. 11th February 25, we received the complaint. Then what we have done, we have categorically stated, the allegation is that police is not taking any step. We have categorically mentioned before the magistrate what is the difficulty.
Is the money in whose account is the money parked?
Now,
That is that person being made a party over here?
no, madam.
Why?
Now, at 30th April, interim order was extended, madam.
Cybercrime fraud, madam. We don't know where the money has now evaporated, but it has been to the SBI.
No, it is parked in some account.
Yes.
The State Bank of India is aware.
Correct. They should intimate that person then, and because we are the victims here.
Who is the victim? The authority will decide.
I am the victim, my lord. The court has.
Yes. What is the bank stand?
There is an interim order, my lord.
Yes.
Account, my lord, and this is a complaint, my lord. The complaint is against this given Polyfax.
Yes.
Given Polyfax.
Interim order.
The writ petitioner before the Andhra Pradesh High Court. Given Polyfax or to Sibama. So they are the accused.
You pass on the details so that that person can be made a party.
Am I right?
They are having. They are having. They are mentioned in the complaint, my lord.
Yes.
In their complaint.
Party here.
Wait, is their name mentioned anywhere in the complaint?
Yes,
kindly see the writ petition.
And even then, you did not make that person a party?
Yes.
Page 35.
It's 35.
35.
It is the account na.
So since confronted Jivan Panasim.
My lord, the account holder Orchu Sivamma, given Polyfax, given Power.
My last week, interim order was extended, madam. I have given the order copy to the judge.
Andhra Pradesh High Court.
Yes, madam.
Interim order is extended. List the matter after summer vacation. When is the summer vacation ending over there?
15th of June.
15th of June.
15th of June.
Make parties. Please come.
Party at
The petitioner prays for return of the money, which is lying in the account of one Jivan Polypax and others. Stop. According to the petitioner, the money is a subject matter of a cyber fraud committed upon the petitioner. Stop. The petitioner relies upon the order passed by the learned Additional Chief Judicial Magistrate, Calcutta, wherein direction has been passed upon the investigating officer of the case. Now, upon the nodal officer / branch manager of the State Bank of India to transfer the amount of rupees 43,94,230.83 from the account number, page 40 te dekhben to lekha ache, to the account of the petitioner upon submission of a Zimmanama bond with condition to produce the sum before the court or any other court of law as and when directed. Stop. Learned advocate representing the bank and the police relies upon the order passed by the High Court of Andhra Pradesh at Amravati in writ petition number 7249/2025 in the matter of Jivan Polypax and others versus Union of India and others, wherein an interim order has been passed directing the official respondents to maintain status quo in respect of the subject sum of money. Stop. The interim order is subsisting till date. Stop paragraph. It appears that the petitioner, even though aware of the details of the account and the account holder where the money is alleged to be parked, has not impleaded the said person as party respondent in the instant writ petition. Stop. Any order passed directing refund of the money, refund/transfer of the aforesaid amount from the account holder without notice will cause serious prejudice to the account holder and will also be contrary to the principle of natural justice. Step next. In view of the above, the leave is granted to the advocate on record of the petitioner to implead the account holder as party respondent in the instant writ petition and serve copy of the writ petition upon the added respondent. Released the matter on 23rd June.
Only thing, report filed by the police authority.
Report filed by the
officer in charge, Posta police station.
Officer in charge, Posta police station. Dated 5th May 2025, be written with the record.
And your lordship recorded, additional chief judicial magistrate, Calcutta. It will be additional chief judicial magistrate 1, Calcutta.
Acha, 1 Calcutta.
Roman 1.
Yes.
I am appearing for the writ petitioner in this matter, my lord. And it was moved on the last, just before the vacation, my lord. My learned friend had taken a point of maintainability. Now, this is a order which is styled as an award passed by the MSME Facilitation Council. But my learned friend's objection as to maintainability is there is an adequate remedy under the Arbitration Act. Therefore, the order cannot be challenged by way of Article 226. Now, this specific issue has been considered by the Honorable Supreme Court. Now, the question is, every order which is being passed by a facilitation council as an arbitrator does not become an award automatically unless it is passed in the manner and within the four corners of the jurisdiction envisaged under the Arbitration Act. Suppose, my lord, a arbitrator passes an order as an award after 5 years without any recourse to Section 29A of the Arbitration Act, where the time is specified. It does not become an award under the Arbitration
In this
Act.
case,
Yes.
was the order passed, the impugned order was passed upon hearing all parties?
We were not
on
represented.
merits.
We were not represented.
Not represented means what? Notice was given to you, you did not appear?
Yes, yes. Because our point from the beginning was that the proceedings started being without jurisdiction contrary to the provisions.
Right. Was this fact brought to the knowledge of the arbitrator?
Yes, and also, my lord,
and did the arbitrator return any finding?
No. We filed a separate writ petition, earlier writ petition
All right.
on that. An earlier writ petition was also dismissed on the after hearing, also on the ground that you have a remedy under Section 16. At that position, at that point of time, there was no award, no order style as an award. Because, my lord, we had challenged the initiation of the proceedings, registration of the case as an arbitration proceeding. Then, my lord, in the appeal.
Well, but then this matter is to be heard.
Yes, my lord, it is to be heard. My lord, I will be relying.
Otherwise-
I'll tell you, lordship, my lord, for this.
Well, in that case, would you like to file an opposition?
I have taken out a demurrer application, which is also in the list.
GA1?
Let
Yes,
that
my lord,
be
GA1.
heard. I will make my submission on that.
GA1.
You can file your affidavit in the GA if you choose.
I'll say that it will.
Very well, not required.
Because it's only on that question whether a
Right.
writ petition under 226 is
Will be
maintainable.
maintainable or not.
And
Very
I
well.
just apprise your lordship, my lord, Supreme Court in a Jharkhand Urja matter of 2-judge bench has held a writ petition under Article 226 will lie against an order.
Very well. I'll hear
Again,
you,
my
but
lord,
not today.
Yes, but again, my lord, I shall also apprise your lordship. Again, in another subsequent judgment, this specific question has been referred by the Supreme Court to a larger bench. Now, the larger bench is not there.
So, my lord, my submission, I will also rely upon a Supreme Court judgment to say that if an issue is pending before the larger bench, then the law as it stands shall prevail. That is the earlier position, which is the Jharkhand Urja matter, and your lordship is not precluded from deciding on the basis of the law as it is standing, my lord.
And my lord, my submission would be, my lord, basically
Next day, I'll hear
no,
you.
what he's doing, he's proceeding because there's an arbitral award. There is no setting aside application. Your lordship is aware that an award under the 96 Act.
An award.
No, that
My
is,
point
of
is-
course.
I'll hear
He
you.
has been saying that from the very beginning.
Yes.
Initially, he said there is no arbitration.
An application has been filed by the respondents.
Two.
Respondent
Second
number two,
respondent.
Your Lordship, one indulgence.
challenging the maintainability of the writ petition. Stop. Let the application appear in the list for consideration. Next week, I'll keep it.
Yes, kindly, my lord, keep it, my lord.
Any day convenient.
Next
Any day
week.
convenient.
17th of June.
Your Lordship, the MSME Council has been also made a party as respondent number 1, Your Lordship.
Yes.
Your Lordship, I
Any
also challenge the maintainability. Yes, Your Lordship, I also challenge the maintainability. Your Lordship, in that case, within this period, I shall also file a very short affidavit to this
Well, it's
writ
not
petition.
necessary, my lord. The point can be urged.
Application, there is a demurrer application. If that is heard, then your case is also taken up for consideration, isn't it?
Yes, yes,
Because
yes.
your case and the respondent number two's case is the same.
Your Lordship, in that case, I would just request Mr. Bose to ask this AOR to serve a copy upon copy of that G upon me. Because I don't
GA
have.
application serve upon Mr. Dinda.
Very well, very well.
Right.
We'll do that.
17th of June.
Great,
Record his presence. Don't call hearing matter.
My lord, may the notice of motion along with GA1 may be kept on record.
And has this notice been served upon the
Yes,
respondent number
of course,
one? In
absolutely.
that case, Mr. Dinda has
Not respondent number 1, but upon the writ petitioner,
on the writ
as we will
petition.
serve upon the respondent number 1 as well.
Possibly not.
We will serve upon the respondent.
Mr. Dinda.
No, my lord, this is for the
Yes,
court
yes,
practice.
yes.
I will.
Put on record,
Fine,
but
fine.
let copy be also given to him.
Will do, my
My lord, may I trouble my lord? There was
First hearing matter.
Lordship, because the matter's been settled, we just need consequential orders.
Yes.
My lord, since we had mentioned it, Lordship had kept it top of the list.
What is the
today.
consequential orders?
My lord, this was a case of declaration of fraud
Yes.
by Axis Bank on the basis that I have not repaid the loan. Subsequently, Lordship, I was declared fraud on the basis of a stock audit report which was never given to me. So the first ground was that you could.
What is the
Now, Lordship, we have
consequence?
the matter's been settled. We have repaid the dues. We have received a settlement letter from Axis Bank. The only prayer is, Lordship, the declaration of fraud as a consequential act be set aside because the
How
basis.
can that be?
Lordship, it's been settled. This matter, the similar point went up to the Honorable Supreme Court in case of criminal proceedings where allegations of fraud were made, in case of settlement of dues by banks. What has been held by the Honorable Supreme Court is that, Lordship, the premise for declaration of fraud is the non-payment. Now, the moment the payment happens, the
Does the earlier order declaring you as fraud goes?
Well, it does not go on its own, but the basis
What is
for
the stand of the bank?
Your Lordship, first of all, the declaration of fraud was not on the ground of non-repayment.
So it cannot be done.
It
No
was
order can be
no,
passed today.
my lord. It was the
there-
forensic
Sorry,
audit
my lord,
report
may I
duly
just- may I
provided
just
to
place-
that. I will
As and
place.
when it is
I will
My lord, there
place
is because
the judgment where it is
appellate side
stated
matters.
that it cannot be revoked.
My lord,
It cannot be done.
my lord, it's there in the Supreme Court
Very
judgment.
well,
Lordship.
next day when it is taken up.
My lord, kindly keeps it tomorrow, Lordship.
It will be there in the list
great.
today. 1 hour mentioning took place.
I appreciate
It is only for this that it could
We'll-
be taken
we'll
up.
take our chance tomorrow.
Please,
Great.
it will be there in the list.
Great.
What is the correction? কি ভুল হয়েছে? Very well. Lordship, I for the corporation.
Item number 2, I'm for the petitioner, my lord.
Number 2, I'm for the petitioner. It's for withdrawal of the matter, my lord.
Who is he?
My senior, my lord.
My lord, this was filed for the non-supply of the certified copy. After filing the writ petition, we have received the certified copy from the department, and my instruction is not to proceed with the matter. And
The
instruction,
relief
my
sought for
learned
by
junior
the
will hand
petitioner
over
has
the.
already been allowed by the respondent authority. Stop. The petitioners do not intend to proceed with the petition any further. Stop. In view of such submission, the writ petition stands dismissed as not pressed. Instruction from the petitioners to the advocate be retained with the records.
দু নম্বরটা দিয়েছে
Item number 3, my lord, I'm appealing for the petition. My lord, this has been assigned to your lordship's court, my lord, pursuant to a Supreme Court order, my lord, which has been passed. My lord, may kindly takes up first this order.
Yes, Lady.
And this was the last order passed by this honorable court, my lord. I'm giving both. Then I'll come to the facts of the case, my lord.
Who is your other side?
My lord, we have served upon the other side. Right, my lord. They had appeared also. Irresponsible. My lord, accordingly, this matter has now been assigned to your lordship, my lord. Just to give your lordship a brief background, my lord.
No, without the other side, brief background will not help because this is a assigned matter and the other side may not know that the matter has been assigned. Right. So please give
may I, my lord, indicate to the state, my lord, the matter is appearing. And my lord, lordship may kindly fix a date, my lord, day after tomorrow.
Day after tomorrow?
Duplicate, my lord. Bolo, day after tomorrow.
Ashwin, the matter has been assigned before this bench. Stop, let notice be served. Upon the learned advocate representing the respondents, intimating that the matter will appear in the list on 11th of June. Is there any private respondent? There appears to be a private respondent.
Yes, my lord. I'll serve upon her also.
How will you serve?
My lord, we will serve, my lord, by way of speed post only. Lordship lordship keeps it on Thursday then.
Yes, because speed post Thursday also it will not be possible. Is the private respondent represented by any learned advocate?
My lord, they are represented, my lord. We will serve it upon the learned advocate, keeps it day after tomorrow, my lord. We'll represent it, we'll make sure that they appear, my lord.
বৃহস্পতিবার দিন রেখে দিন।
Duplicate.
12 তারিখ।
Learned advocate ke service ke duplicate. My matter may retain its position in the list.
Yes, yes.
Duplicate.
এই অর্ডার গুলো রেখে দেবেন।
Item number 4, Lordship, I appear for the petition. I'm led by Mr. Jishnu Chaudhary. He's supposed to be appearing virtually, but I'm ready in the matter anyway. If Mr. Chaudhary is not available, Lordship, I'll start because there's some urgency.
My lord, I appear for the defendant.
Defendant?
Respondent.
This is a
South Indian
Bank Limited.
South Indian Bank. Mr. Diwan is there. Right?
Yes, Manoj, I appear for the respondent bank.
Malad, what has happened here is
seeing the volume of the papers. I'm not feeling like touching it also.
But Lordship, for today's purpose, Lordship, it's very short.
Yes.
Lordship has been hearing these batch of matters which concerns declaration of fraud by various banks relying on the same audit report in respect of the two Shrey entities. And we are two erstwhile directors. The management was superseded by RBI. Several litigation happened. New management taken over, new resolution plan, everything done. However, after that, the two erstwhile promoters have been sought to be charged with fraud. They've been sought to be declared as fraud or perpetrator of fraud by these banks, by a consortium of banks. Lordship has already heard matters pertaining to the same audit report, but in respect of different banks. and Lordship has passed orders. Now here what has happened, once the show cause notice was issued, Lordship knows with all the documents which are the basis for the show cause notice have to be supplied to us. In this case, there was an audit report. Now, the forensic audit report relies on several documents to arrive at its findings.
And without supplying those copies
to us, the show cause notices were issued. Several writ petitions were filed. In some of them, there was a judgment by Honorable Justice Bhattacharya. Thereafter, the declaration of frauds was set aside. The show cause notices were kept in abeyance, and a procedure was laid down, which Lordship Mr. Chaudhary had placed on the last occasion in a similar matter, as to how the documents are first to be given to us. After the documents are given, a notice of personal hearing is to be given. We will appear in the personal hearing, and thereafter a decision will be taken by the bank. Now, in case of this particular bank, in item 4, what has happened? The show cause notice was issued. We gave a reply asking for all these documents, particularizing them. Those documents were not given. We filed the writ petition, which has been pending before your Lordship. In the meantime, what they've done is, they gave us a notice for hearing. We responded by saying that I have already responded to the show cause notice asking for the relevant documents. Kindly provide us those documents. After that, you call us for a hearing. We are ready to participate and ready to cooperate. Please only provide us with the documents. They unilaterally sit on the High Court's judgment and say, these documents are relevant, these documents are irrelevant, we will not give them to you, and some of the documents are not in their possession. Despite that, they give us a last hearing of notice, notice for personal hearing. We again give the same response. They disregard our response and have declared us as fraud. So we have filed a CAN application, Lordship, like we've done in some of the other matters. Lordship has passed orders staying the declaration of fraud till the documents are given. All that we ask for today is kindly let the documents be given to us. We have still not understood the prejudice which will be caused to the bank if all these documents are given or inspection is given.
List of the documents which you require.
Lordship will kindly see page 92 of the CAN which we have filed.
Is it CAN?
We filed a supplementary affidavit first, and subsequently there's a CAN. Lordship will see the supplementary affidavit, page 92.
Supplementary affidavit. Is it there in the CAN also?
Is it? No, I believe it's not annexed to the CAN, but we had filed it, Lordship.
You have filed it means it's not annexed with the CAN and you have filed it.
No, the supplementary affidavit, Lordship, was separately filed. I'll just kindly give me. Oh, I stand corrected. It wasn't. It's the first time it's coming.
Right. So how can the supplementary?
Lordship, I stand correct.
I was hunting for it.
I stand corrected, Lordship. Lordship,
and is copy of the supplementary affidavit served upon the respondents?
Yes, it's been served on the. It's been served on the long time ago.
Prior to handing over the copy to the court, prior to taking any leave, you hand over copies and everything. What is happening?
Lordship, this may I clarify this, because this concerns Lordship. Mr. Diwan has been appearing for the other banks in respect of the same matters. It all concerns the same report, the same consortium, other banks of the.
Where is the list?
Lordship, page 92, if Lordship.
The documents which you require from them.
Kindly see page 92, Lordship.
Page 93.
It starts from page 92, Lordship, enclosure A. And
yes, and it goes to how many pages?
Lordship, it goes till page 99.
99.
This is all that the forensic audit report has relied on to come to a finding. This submission has been accepted by Honorable Justice Bhattacharya, Honorable Justice Shorkar, and by your Lordship. Lordship has given directions in other matters where the banks have taken other banks have taken a fairer stand. They have said that they've taken time from your Lordship to go and get these documents from the auditor and supply it to us.
1 minute. Respondent bank.
Yes, my lords, I beg to appear.
Pages 92 to 99, there is a request for supplying these documents.
Yes.
Where these documents supplied to them?
My lords, may I request your ladyship to, my lords, take these matters one by one. If your ladyship is entertaining item number 4 right now.
One by one means right now I am in item number 4.
Yes, now, my lords, in item number 4, the only important thing your ladyship should first ask the council is, when were the documents sought?
All right.
Because that's very important. The judgment of this honorable court says, and that is the mandate of the RBI Master Circular also, that once the show cause notice has been issued, within 21 days a response needs to be given. The judgment of this honorable court says that you may, after giving or at the time of giving the response, you may indicate whatever documents are required. Now in this case, now I am now on item number 4, which is the writ petition by Mr. Sunil Kanoria. The show cause notice is dated 16th of May 2024. So if at all a response had to be given or documents had to be indicated which they were relying upon, they should have told me by in 21 days. However, my lords, in this case, the request for documents comes for the first time on 10th of December 2024. That's important, because a person who really believes that documents are required should be forthright in asking for those documents. Now, this person does not give any response at all. My friend kept referring to the judgment of this honorable court by Justice Bhattacharya. That judgment is very clear. It says that if the show cause notice is received, you give a response. If you believe that you are not able to fully respond and need some additional documents, indicate that in your response itself. Now, this gentleman does not give a response at all, and he asked for documents on 10th of December.
What is your response to the request made on 10th of December 24? Did you respond?
Yes, my lords, there is a response. Yes, there is a response by the bank to that, my lords. That is at page number 100. We responded on 11th of December.
And what did you say?
My lords, in that response, your ladyship would see, my lords, we have said and we have, my lords, extracted the High Court order.
Lordship, that's page 100 of the supplementary affidavit.
Yes, 100 of the supplementary affidavit. I'm sorry. Oh, I'm sorry. I thought your ladyship was looking at supplementary affidavit.
Well, because all this happened after we filed.
Wait. Not all together. Page 100. Yes.
Now, let us kindly see. We have extracted the High Court order.
Hmm.
Now, paragraph 7, although respondent banks have served a copy of the KPMG forensic audit report to the petitioner, respondent's counsel will serve a full copy of the KPMG forensic, which is done now. Forensic audit report was given. Now, kindly see the next, this is extraction of the High Court order. Look at paragraph number 9. Upon such reply being given, respondent bank each of the writ petition shall fix a date for giving inspection of documents extremely voluminous so-and-so. Bank shall furnish copies of relevant documents to the petitioner within a fortnight thereafter. Upon being so served, petitioner shall, if necessary, give an additional reply in light of such documents. Such additional reply shall be given in outer limit of 21 days from inspection furnishing copies of documents. But please read paragraph 8. I'm sorry, I should have read paragraph 8. Petitioner in each of the writ petitions would furnish his reply to the show cause notice within 21 days from today, indicating documents which are required to be inspected, furnished by the petitioner to effectively rebut the allegations made therein. Now, there is non-compliance of paragraph number 8 on the face of it, because there is no response at all. My friend has straight away jumped to paragraph number 9 and 10. There is no response given. And please, your ladyship will keep in mind, his brother, the current petitioner, Sunil Kanoria's brother, has also filed a CAN 1 in item number 5. The contrast between the brothers is, one brother, which is the petitioner now, gives no response at all, seeks documents straight away. The other brother, he has given, as indicated in this order, he has given a preliminary response and then sought documents.
No, in item number 4. Where is the
yes.
show cause notice? Is it there in the supplementary?
No, Mulad, that is in the writ petition, page 661.
It is there in the writ petition and it is dated
16th of May.
16th of May. Did the petitioner give any response to it?
No.
No response. The first communication is on 10th of December 2024.
No, there is one communication in between. There is, my lords, a letter on 18th of June 2024 where no documents are sought, no response is given. We are only told that the writ petition is pending. Don't move ahead. That's all. Now, filing of a writ petition doesn't tantamount to a stay under the master circular. So, in my respectful submission, if the petitioner felt genuinely aggrieved or was genuinely incapacitated from giving a response, he was required to indicate the documents to us. He cannot come to the court. Yes.
Will you please show me the show cause notice?
Well, that
is page 661, Lordship, of the
writ petition.
Where does this show cause notice end?
Was
Page 672?
yeah, paragraph 11 is the last paragraph.
And the annexure ends at 675, Lordship.
The forensic audit report admittedly has been given to them with all exhibits. Now, leadership will note that. The forensic audit report with all annexures given, my friend says over and above that, I need more documents. That's the case in the writ petition.
All right, 1 minute. Now, page 672, I can see that 15 days time was given to file a response.
Yes.
Right. And no response was made.
Yes. Only letter is 18th of June at page 19 of the supplementary affidavit, which is not on merits, which doesn't ask for documents, only says that, well, the matter is pending in the High Court.
Get it.
And this letter itself is beyond 15 days or 21 days, as the case may be.
Right. Well, let me hear the petitioner once.
Yes, please.
Lordship, certain misconceptions must be cleared. First is, Lordship, when before
page 672.
Lordship, page 672, this 15-day period, Lordship, Mr. Diwan submitting that it refers to that High Court judgment. That is
No.
not correct.
May not be correct. Page 672, you were given 15 days time to respond. Did
Now,
you?
Lordship, we did not respond. We sent them a letter because we, instead of...
You did not respond.
We filed a writ petition instead, which we've done for all other matters.
Right.
And in all those other matters, Lordship, what has happened is, in fact, subsequent to this also, there were further judgment by consent by Justice Bhattacharya, where show cause notices were issued, and we directly filed the writ petition where
What
we
is the
sought...
stage now? You have been declared as fraud?
We've now been declared during the pendency of this writ petition without giving us inspection of any of these documents.
Nothing can be done.
My lord, may I place the other orders in the identical matters? My lord, kindly seize Lordship's other orders. May I place the other orders?
No.
My lord,
Let them
Lordship's
file the
are...
opposition. Please come.
My lord, because unless the declaration is kept in abeyance, Lordship will kindly see the other orders.
The petitioner is aggrieved by the act of the bank in taking steps for declaring the petitioner as fraud. Stuff. It appears that a show cause notice was given to the petitioner on 16th of May 2024,
45.
calling upon the petitioner to submit in writing within 15 days of receipt of the notice as to why the account should not be classified as fraud under the RBI master directions. Stuff. It was indicated that in case the petitioner failed to respond within the stipulated time period, the bank shall proceed in the matter in absentia as per the RBI master directions and judicial guidelines. Stuff. A letter was served by the learned advocate of the petitioner on 18th of June 2024, intimating filing of a writ petition before the court. Stuff. No reply to the show cause was, however, given by the petitioner. Stuff. On 10th December 2024, a request was made by the petitioner seeking documents which would have been required, which were required for filing reply to the show cause notice. Stuff. The bank proceeded to conclude the proceeding and declared the petitioner as fraud during the pendency of the earlier writ petition filed by him. Stuff.
It's the pendency of this writ petition, Lordship.
What is this? This is
certain important facts, Lordship, are being left out, Lordship. Kindly provide us with an opportunity, because that's not the case. They gave further notices of hearing.
The writ petition, earlier of the writ petition. Filing of the writ petition. ঠিক আছে, next. The learned advocate for the bank submits that had the petitioner genuinely required the documents, comma, then the petitioner should have mentioned the same within the stipulated time period in the show cause notice. Stop. The petitioner sought for the documents at a very delayed point of time. Stop paragraph. According to the bank, the declaration of fraud has been rightly made.
My lady, may I just add 2 lines also, if your ladyship doesn't mind? Even on 10th of December, when he sought the documents, this is after we had given a last and final opportunity of personal hearing. So he really wakes up from his slumber after we tell him we are having a personal
this
hearing.
This is not correct, Lordship. There are several court orders in between, Lordship.
No, wait, my friend will just give me a second.
It has
personal hearing.
Please wait.
Yes.
It has also been brought to the notice of the court by the learned counsel representing the bank that notice of personal hearing was also given to the petitioner. Stop paragraph. As to whether the declaration of fraud was rightly made or not has to be decided upon exchange of affidavits. Let affidavit in opposition be filed within a period of, how soon can you do it?
Well, I can file within 3 weeks. Your ladyship can give me 3 weeks.
Today is 9th, 30th of June.
30th of June, yes, please.
A reply, if any, by 11th of July. Liberty to mention the matter for hearing immediately upon conclusion of the aforesaid time period.
Well, this will be contrary to Lordship's order in exact identical facts and circumstances.
Filed in court today by the petitioner be written with the records.
Lordship, kindly allow me to place the subsequent judgment of this honorable court, Lordship, in identical facts and circumstances.
Item number 5.
Lordship, the facts have been misrepresented. It's not a case where we did not respond because the other petitions were pending and judgments.
Item number 5.
Lordship kindly permits me to place one order of your Lordship in identical facts and circumstances. In fact, there's been a judgment where Mr. Diwan consented also.
No, that is a different case. There's a different case.
There is no consent. Had there been a consent, the court
Lordship,
could have passed.
Same facts, Lordship. It's
You
the same
say
bank,
same.
Lordship. Lordship, it's the same bank, same report. Lordship, it's
Item
identical.
5.
Lordship,
Number 5.
Lordship, item 5 is a similar matter.
Yes. The dates are the dates the same? The date of the show cause notice and everything, is it the same?
The date of show cause notice in item 5 is the same. However, the can is not even maintainable. And I thought my friend will be candid enough to tell to the court, but there is some trickstery played here in item 5. Kindly just look at the cause title of item 5. Item 4 was a single petitioner. Item 5 are 2 petitioners, Hemant and Sunil Kanoria. The 2 brothers have filed together. Now, the difference between item 4 and 5 also, apart from the number of petitioners, is item 4 was concerned with a KPMG report. Item 5 is concerned with a Saxena report. There are 2 forensic audit reports. Now, in item 5, 2 petitioners and Saxena report, the fraud declaration has happened for Hemant Kanoria under the KPMG report. And they have filed a Can 1 seeking a stay in item number 5, which the subject matter is a different subject matter. I hope I'm clear. Let me just try and make good this point. In item number 5, the main writ petition impugns a report called the Saxena report. The fraud declaration, however, has happened under 2 reports, which is Saxena report and KPMG report. Now, certainly, by way of an interim application, if the main subject matter is Saxena report, they can't get an interim order with the KPMG report. However, without disclosing to the court that here the fraud is on 2 counts, a Can 1 is moved as if telling to the court that the subject matter of the application and the writ are the same. This Can doesn't even lie.
Just tell me whether the dates are the same or not.
Lordship, the timelines are not the same. There was no latches in giving a response because this was covered by another order.
And in the response that you filed, did you seek documents?
Yes, we have sought the Lordship. It's been done in all cases, Lordship.
My friend is wrong.
My Lord, may I get my 5 minutes to make submissions, Lordship?
Yes,
without being
yes.
interrupted
Give me
by
the
Mr.
dates.
Diwan?
Give me the dates, please. Show cause notice is 16th of May 2024.
Supplementary.
Again, a
This is
supplement.
here also, because we immediately upon receiving the show cause notices, we filed the writ petitions, which we have done for all other matters. This laches point cannot remain in light of the judgment of Honorable Justice Bhattacharya, as also Honorable Justice Sarkar.
16th of May 2024 is the show cause notice date.
Lordship.
Same. When
Lordship,
did you
that is-
respond? When did you respond?
We gave the response, we filed the writ petition, and we gave a response on 30th August 2024.
15 days was the timeline, isn't it?
Malat, because we, in all other matters where judgments have been passed prior to the issuance of the show cause notices, where Honorable Justice Bhattacharya had set aside or kept in abeyance the show cause notices, the very fact that the show cause notices on similar lines were
So
issued.
within the
Malat,
15
may I-
days period, you did not
Malat,
file
that is irrelevant, Lordship, here, because may I
How?
praise the judgment of Honorable Justice Bhattacharya? Malat, this is grave injustice.
Please come.
Lordship, this is grave injustice. Malat, kindly keep it
Petitioners
tomorrow.
are
We'll come back,
aggrieved
Lordship. Kindly
by
keep
the
it
act
tomorrow.
of
May-
the bank
Manoj, may I just make one
declaring
submission?
To
the
Lordship's full
accounts.
judgment.
In
May-
declaring the accounts
Kindly
has
see page
brought
106, Lordship. It's the same South Indian bank.
paragraph. Learned advocate of the bank submits that steps were taken in terms of the master
Well, it's in violation.
directions of the Reserve Bank of India.
I'm not-
Paragraph. Whether the declaration of fraud was in terms of the RBI master directions are required to be decided upon exchange of affidavits. Let affidavit in opposition be filed by 30th of June. Reply, if any, by 11th of July. Liberty to mention the matter for hearing immediately upon completion of the aforesaid time period. At the first day, affidavit, supplementary affidavit of the petitioners filed in court today be retained with the records. Call item 6.
Lordship, filing the affidavit of
I'm
service.
grateful.
Affidavits of service in both the matters be retained with the records.
হ্যাঁ সেম সেম এই যে আরেকটা ম্যাটার দুটো
item 6.
4-5 এটা কপি দেয়
Item 6.
ওয়েস্ট বেঙ্গল ফিনান্সিয়াল কর্পোরেশন
Yes.
West Bengal
Financial.
I not travel your lordship kindly come to page.
করতেই তো আসছি রাহুল করতেই তো এসছি
Yes. Page.
Manoj, kindly come to page Manoj. Not page 98.
ইয়েস 98 আর 100 দেখাবি এই তো
Yes.
Manoj, this is the e-auction sell notice which is issued Manoj earlier. Now Manoj, your lordship will find that the serial number 19.
What is the date of the sale notice?
This is of the earlier e-auction notice Manoj dated Manoj. This was dated 3rd December. This was dated 3rd December. Now your lordship kindly come to serial number 19.
Yes.
Has your lordship got it? The petitioner here, your lordship. Now your lordship will find that serial number 19 a note has been given. Bids are invited from the tribal persons because the property is a tribal property. Now this was challenged.
Notice.
This notice was challenged. Now your lordship kindly come straight away. Page 100.
Yes.
But this was challenged, the order passed directing the finance corporation to file affidavit, certain document which has been relied upon them, they filed therein, but the copies of documents has not been handed over. Your lordship will find the page, internal page 2, 101, running page. The paragraph starts, my lord, Kerala Finance Corporations versus Vincent Paul. Now your lordship will find from that paragraph, last but it start from in fact in the instant case the petitioners were paying some. Your lordship got it. As per the one-time settlement offer. Now the petitioners are not even informed about that. Now their contention is that was informed. But 30 and 29 notice has been given to us. Now perhaps that was failed. That e-auction. Perhaps that was failed. They again, and this matter is pending. Your lordship will find at page 103, and they have not been given the oppositions and all these things, that is pending, and
Your Lordship will find perhaps that was failed and page 104, the next e-auction notice, as Your Lordship got it.
What happened to that writ petition?
That is pending. Yes, pending. No affidavit of exchange. Affidavit has not been filed by them.
All
No
right.
document which has they have shown.
Now
that has not been-
what is the fresh challenge?
The fresh challenge is, well, Lordship, kindly come to page 104.
All right. What is
Second
it?
e-auction.
Though it is the same thing, they'll give you notice.
Little
No,
difference is
come,
there.
come. It is there. Your Lordship will come to my the that is serial number 10.
That note is not there.
No, that note is not there.
You are troubled by that?
Yes. Not only that, my lord, in the meantime, my lord, they, after filing of this, my lord, this was appeared on 3rd of 21st of May. Before my lord was not sitting at that point of time, 21st of May, this month, last month. Now, my lord, during the pendency of this writ petition, my lord, they served a notice on 23rd of May, the last day on the day of before the summer vacation start. I have received that, my lord, your lordship. I need to, my lord, file a the applications to that effect. Your lordship, kindly see this notice which has been given to us. They have got a bidder, but subject to, my lord, they are very much willing to, my lord, consider our aspect. But the thing which I need to, my lord, your lordship, kindly come to the first page of the notice, the second paragraph. Your lordship will find the second paragraph which has start, my lord. It is hereby informed. My lord, this, your lordship, first, your lordship, kindly come to the first paragraph. You are aware of the terms of loan of 40 lakhs. As your lordship got it. This is 40 lakhs, which has been disbursed on 31st of March 2009 to, well, this is a continuous loan payment because of the cash flow, and 27th of January 2010. As your lordship got it. Now your lordship kindly come to the next para. It is hereby informed that despite of allowing several opportunities to regularization and liquidation of so-and-so account, you fail to so-and-so this alarming in a liability of 1,215,000.
No, see, now the reserve price is
now your lordship can see
68 lakh.
1,02,000. Your lordship kindly keep it to the 1 lakh.
2 crore 68 lakh is the reserve
I am
price.
not on that, your lordship. That paragraph I am going to that paragraph. You kindly accept this. The paragraph starts this: if it is hereby informed. And your lordship on the next third line. Your lordship kindly see, still in a liability of 1,215,000 towards the principal. Now its amount to interest 87 crore. But a loan of 40 lakhs, your lordship will find. But I have to file an applications. That was taken into, because during this period, I have already, my lord, paid a sum of rupees in respect of that settlement amount, and that was continued. Now they are asking, my lord, this amount, and they are now the bid. Well, you also can see. Second point is this judgment is there, my lord. 14C has not been complied with. So far as the West Bengal Land Reforms Act is concerned.
Land reforms?
Yes, because this is a tribal property.
Yes.
So
yes. The bidder,
yes,
who they have found, whether the bidder is a tribal or not.
There is no note about. Let them say this is this is a tribal property. Only the tribals are. There is no note such as. But last occasion it was there.
Previously there was a note.
Yes.
Is it your case that they are trying to sell out the property to non-tribals?
They have already got the bidder who is not at all a
tribal.
Tribal
is not a tribal.
And my lord, the opportunity though in this my lord, notice, opportunity though has been given. My lord, I have to take the time. That's because this has been sent to me on 23rd of May.
Yes.
So when I received.
No, 30 days time has been given to you.
No, this notice, the notice I have handed over 23rd May.
Yes.
There your lordship will find at that page.
Either you have to match the amount that is being given
that by
the
your lordship, yes, that your lordship on the next page of the notice that is stated therein.
Yes.
Last paragraph, the corporation, however, before dealing with the sales assets, so and so has been given. So the opportunity has been given by this 23rd notice. So 23rd notice, my lord, I received into after that 23rd. So my lord, let me have some time to deal with this.
What dealing? Either pay or go.
No, matlab, one thing, your lordship kindly see, even if how this calculation come to 87 crore out of matlab, 1 lakh something, what is the principal amount?
Now calculation portion, the read court will certainly not go into.
That the direction was there, matlab, the Supreme Court has already matlab, how matlab,
The
then
read
the
court will
valuation,
go into
then the valuation, matlab, your lordship will find that the valuation, whether the valuation, matlab, they have only told the direction was there to file affidavit with the documents showing that this calculation has been made and the matlab, valuation has been drawn by the matlab, but that has the earlier it is pending, matlab. I am not on that.
Why have you filed writ petition? Why don't you file a suit?
Matlab, this was that. Then another thing, matlab, the
Let me hear.
position.
What can be done?
I don't know what is his challenge.
Yes.
The challenge is that matlab, this notice has not.
1 minute. Are you handing it over to non-tribals?
My lord, sources more the booth. What happened, my lord? The land is not a tribal land.
Not a tribal land?
No, I'm coming to that. What happened, my lord? I shall not say I advise my client to take steps. In the earlier notice, insertion has been made tribal.
Yes.
Why? Land originally belongs to tribal.
Yes.
Thereafter, the tribals, by a deed of relinquishment, everything has been given to a company and company mortgaged this property to me. The company land cannot be a tribal land. Kindly see this. Be satisfied. Kindly see this.
4th of December 1995.
Kindly come to page 2. This is the registered document. And whereas the releaser have offered the said 8th schedule property to the company as consideration for the issue of 5,000 shares. So consideration also there. Equity shares to the releaser in lieu of the property referred above, and whereas the releaser have accordingly surrendered and relinquished their right, title and interest over the property as described in the schedule. Is already been transferred in favor of a company, and the company's property has been mortgaged with the financial corporation.
Was this recorded?
Yes, this
updated in the records of the state? Was this updated in the records of the state?
Registered document, my lord. This has been produced by production of this deed. It was mortgaged. Now it cannot be said this is tribal property. And for your lordship's satisfaction, my lord, the bidder is also a tribal.
Bidder is also
a tribal.
Then do
and
not
what is
go.
asking for? Under the judgment of the apex court, we have given to match the offer. Either he is to match the offer or not at all. Nothing in between. And so far as the interest part, he is bound by the agreement he has entered into. Penal interest will charge automatically. That's why I see what is grievance is actually.
Who is the bidder?
Bidder, my lord, নামটা বলতে পারবে? নামটা, according to my instruction, he is also a tribal.
Company?
No. Company, individual. MSTC is bidding that. We have came to learn that he is also tribal. But irrespective of the fact, the company is the owner of the property. That has been mortgaged. So character goes. This is the
subject to my senior learned friend is concerned, my lord. Well, lordship is aware of these facts that the 14C that cannot be ignored. Even when transferring, even when transferring a property, well, lordship is aware of this.
Whether listen,
if he says this,
whether the calculations have been rightly made or not, it is not for the writ court to see.
I am
first. Second is, according to the company, respondent corporation, not company, corporation, the bidder is also a tribal. Is also a tribal. So you cannot say that it is being transferred to a non-tribal. So that point goes.
It's not on record, as you
it is on instructions. That point also goes. What remains? Either
remains is that 23 main notice.
Which property has been mortgaged by the company, not by the tribal?
I have followed it. Assuming it has been done.
Can be assumed.
Assume that it is a tribal. What can be done? What is the best relief?
23rd.
Either match.
Yes, that your lordship may give some time because this 23rd notice has.
What will the court
But
extend
this,
time.
no, no, I'm not on that. Matlab, the notice has been served to us on 23rd May.
Yes. Act in terms of the notice.
23rd May.
Yes.
No, matlab, this matter today appeared. And I need
days is
to
a
file,
statutory
matlab, I am
time.
not on that. In the meantime, I asked my client to match the bid, whether it's possible or not. 7 or 10 days is required. And in the meantime, I will brought on record these documents.
That you bring on record,
No,
but then thing is, you have
I
got
will wait
time
because, I filing
within 30 days
Under
from
the
the date of the letter on receipt of
This is
the
under the
amount.
statute.
Yes, 30. That from
30
the
days.
23rd.
30 days you take time and you act
Yes,
in
my lord.
terms
But
of
that yes. But that has been received before, my lord. Not my lord. Before this writ petition comes into effect. My lord, that should be.
The petitioner is aggrieved by the steps taken by the West Bengal Financial Corporation to recover the loan amount. Stop. The e-auction sale notice of December 2024 is under challenge in the instant writ petition. Stop. No. Sorry. Was under challenge in WPA 28533 of 2024, which stood disposed of by the court on 4th December 2024. Dispose na. কি বললাম? Wherein an order was passed by the court on 4th December 2024, directing the respondents to file affidavit in the matter. Stop. The court directed that the steps taken by the respondents shall abide by the final result of the writ petition. Acha. Paragraph. It has been submitted that even after expiry of the time limit fixed by the court, affidavit in opposition has not been filed by the respondents. Stop. A further e-auction sale notice was published in April 2025. Stop. The petitioner has challenged the same in the instant writ petition. Stop. During the pendency of the writ petition, the corporation, by a notice dated 23rd May 2025, has intimated the petitioner to pay the sum of rupees 87,86,29,009.54 together with further interest and other dues within 30 days from the date of the notice. And on receipt of the amount, the corporation shall release the mortgage and hypothecation charge on the secured asset. Stop. The notice further mentions that in the event the petitioner fails or neglects to pay the entire outstanding dues, the corporation shall proceed to sell the entire fixed asset, including land, building/shed, plant and machinery, and miscellaneous other fixed assets Stop. Paragraph. The petitioner submits that the fixed asset belongs to a tribal and the corporation is taking steps to transfer the same in favor of a non-tribal, contrary to the provision of law. Paragraph. It has been submitted that the secured asset has not been valued properly. Stop. Prayer has been made to restrain the authority from proceeding with the e-auction sale notice. Paragraph. Learned counsel representing the corporation submits upon instruction that the bidder who has responded to the impugned e-auction sale notice is also a tribal. Stop. The subject property was
I can refer that document I have.
The subject property was put to mortgage by the company in whose favor the tribals had executed a registered deed, relinquishing their rights. Stop. Paragraph. It has been submitted that the notice dated 23rd May 2025 has been issued in accordance with the provisions of the State Financial Corporations Act, 1951. Stop. The petitioner may either match the amount quoted by the highest bidder. Stop. Next. It appears from the submission made on behalf of the parties that certain amount is admittedly due and pending from the petitioner to the corporation. Stop. The loan account was availed, the loan amount was availed in the year 2009, and in 2025 the amount calculated by the corporation is around rupees 87 crore and odd. Stop. Whether the calculation has been properly made or not is not open for scrutiny before the writ court. Stop. Paragraph. The corporation has published a notice, has published a public notice for e-auction and sale. Stop. A bidder has already responded to the said notice and has quoted a bid amount. Stop. It will be open for the petitioner to either match up the bid or to pay upfront the amount that is due and payable to the corporation. Stop. The corporation may proceed with the sale strictly in accordance with law. Stop. The notice dated 23rd May 2025
then my lord, may I interfere, my lord? 27th is corrigendum also issued, my lord. Just I received a copy. There, my lord, they have quoted the date by which 30 days which will going to be expired, that has been given therein. But the subsequent
date. What is the date?
Date is 25th of June.
I'll mention that by 25th you pay.
That
Yes. We have issued the corrigendum.
Achha. Give. I'll keep a copy in the records.
This corrigendum.
A corrigendum notice dated 27th May 2025 was published by the corporation mentioning that the consideration amount has to be paid by 25th June 2025. Stuff. The corporation shall follow the date as mentioned in the corrigendum notice dated 27th May 2025 and permit the petitioner time till 25th June 2025 to match up the bid or to pay the due amount. Stuff. The writ petition stands disposed of.
Your Lordship, kindly
In
keep
the
it.
event
E documents
that your Lordship,
they are unable to match or the pay.
that
will
in this
proceed.
petition, then your Lordship can.
I am not doing. I am not.
That on that particular day, 26th of 25th is the date. Let it be appear on 26th of June.
Why?
Because
if you fail, you fail.
Yes, because
then
that
is
here in my writ
no. I'm not passing any order. I have key. Taken on record, and they are not filing supplementary.
But the earlier petition can be treated as a days list and become
yes, it becomes infructuous. Exactly. Earlier petition, what remains? Nothing remains.
Mention the order that taking days list and on consent is a disposal.
No. He will not give consent. Let the matter appear in the list.
So there is no bidder. So that's why it has been cancelled and new bid has the offer has been.
Janababu, লিখুন তো WPA 285. Client will not give consent and let the advocate not be put to
affidavit
trouble.
of service be kept.
Yes, service is taken on record. The matter will appear in the list. Please keep a watch. এটাকে টু বি মেনশনড হিসেবে নিয়ে আসবেন।
আমাদের চারজনের মেলালে আপনার কি
Yes, my lord, I beg to appear on behalf of the petition. My lord, this is the affidavit of service.
My lord, I appear for the private respondent.
I appear for Inal Corporation. Lord, the
IOCL, wait, let me
yes,
see.
my lord, the
IOCL.
Lord, I have a preliminary point.
National Highway Authority, who will be representing?
I have served, my lord, upon them, my lord.
Union of India? No. NHAI is represented by a different council.
I have a preliminary point. Kindly come to paragraph 6.
Yes.
He says that your petitioner state that being aggrieved by the illegal act on the part of the respondents, a complaint letter was submitted by one associate of the petitioner number 1 to the respondent number 3 and 4 against the illegal permission given to the IOCL associate. Now, that person's name, Lordship will find the annexure as annex at page 74, Animesh Boiddo.
Is not a party?
No. He's a party. He's not a party. He filed an independent identical writ petition, was completely suppressed in this writ.
May I submit?
Oh, 1 minute. I didn't get. Which page did you refer to?
I refer page 74, the only representation by the petitioner. It's not by the petitioner, by Animesh.
He petitioner is Shankar Fuel Station.
Yes, Shankar
represented by. Shankar is represented by somebody.
No, my lord, Sarkar.
Is a partnership firm, Sarkar.
Sarkar.
All right, Molay Kumar Sarkar.
So Shankar has no representation, 0. Animesh has a representation, Animesh has a writ petitions, and Shankar says that Animesh is an associate. Still, Shankar doesn't say about it and suppresses it.
May I submit, my lord?
Where is the writ petition of Animesh?
Yes, that is
item number 248.
Let both be taken together.
Yes.
Fair enough.
I do not have any objection.
Yes. Are you representing the petitioner in 248 also? Yes. All right.
Because
You
I have got the yes, my lord, I have got the information.
Let him place his case. Excellent. Good.
Well, 248.
Yes.
Are you appearing in 248?
Well, T4. I have not
IOCL. IOCL.
I am representing entire 248.
And I was not even made as a party.
You are not a party?
No.
In that matter, my lord, he was not made a party.
All right, then let us make things clear. 248.
আমি বলতাম আমি এসছি পিটিশন আমি বলতাম আমি বলে দিতাম কারণ হচ্ছে
আমার কাছে যখন পিটিশন এসছে আমি তখন
অনিমেষ বৈদ্য,
100 কেন
when do I keep it? In the meantime, notice has to be served. Is it so very urgent?
because my lord,
Not at all, my lord.
my lord,
He has a petrol pump. He doesn't want me to get it.
All right. So
my
it
lord,
is
if
not.
your lordship kindly sees the memo issued by the NHAI authority. I'm just reading.
NHAI is also not appearing.
I have made the constructions.
27th of
I have
May.
invested.
For 1 minute.
I have received
27th
the
of
oil
May.
also. He doesn't want me to operate.
27th May.
Yes,
What does it say?
27th May, my lord, it has been issued. My lord, I have received, my lord, day before yesterday. My lord, para 3, my lord, right hand side.
Yes.
Competent authority of the NHAI has conveyed approval of so-and-so in grant in principle and provisional NOC for construction of approach road to the proposed retail outlet of Indian Oil Corporation Limited. However, further clarification was sought from the IOCL till submission with the clarification the NHAI requested Mrs. IOCL to stop the construction of approaches within NHAI row. Final approval of the proposal retail outlet is yet to be accorded by the NHAI. That is there. After filing of this writ petition, they have verified it. They have.
No.
I have raised the objection. That objection has been classified, and it has been found that yes, within 500 meters it has been installed. For such reason, they have requested to the IOCL to stop the construction.
All right.
This is the situation. If your lordship tomorrow or day after tomorrow, any day.
Well,
Day after tomorrow
I
will
will
not
have
be
a
possible because are you aware who appears for NHAI?
Yes, Lord, I shall, because I shall serve upon him also personally, because yes, Monica Roy.
Very well. In that case, please serve. Let the instant writ petition.
Paromita Banerjee also. Monica Rai and Paromita Banerjee.
Whoever, please find out and serve. Let this writ petition appear in the list. Day after tomorrow, I keep it.
Yes.
Not be possible. When will it be possible? With WPA 7776 of 2024, Animesh Boiddu versus Union of India and others. Let all the respondents be put on notice. Yes.
My lord, I'm grateful.
Serve notice and ensure
Lord, I shall.
that they appear.
I'm going to
IOCL, take instruction. Yes.
Item number 8, I beg to appear on behalf of petitioner. Restriction already been indexed to us.
A writ petition, learned advocate for the petitioner submits upon instruction that the writ petition has become infructuous. Step in view of such submission, the writ petition stands dismissed as infructuous. Yes, next.
This is my writ petition, Lordship. I'm led by Mr. Shuddhaswata Banerjee in this matter, Lordship. This is a tender was floated by the Northern Railway.
Who is here other side?
Union of India, Lordship. I have served.
Union of India, which department? Who is the answering respondent?
The Western Railway, Lordship.
Western Railway. So in the absence of the railways, will it be
It has been served, Your Lordship, through mail as well as by speed post, Your Lordship. It has been received by them.
Does the cause of action arise within the jurisdiction?
Yes, Your Lordship. Lordship, if it can be kept tomorrow, I'll serve once again through email. I'll intimate them.
Where does the cause of action arise?
Your Lordship, the purchase orders were issued, Your Lordship.
Where?
Your Lordship, a tender was floated by the Northern Railway.
Which page?
At page 98, Your Lordship. Sorry, Your Lordship. At page 40.
40?
40, Your Lordship.
Yes.
The
2022.
petitioner. Yes, Your Lordship. They have the petitioner participated in it.
Right.
And the LOA, the letter of acceptance, was issued in the year 2023, Your Lordship, 31st January 2023.
Yes. Which page?
At page 98, Your Lordship.
98.
And in terms of the tender document, Your Lordship, the railway was to issue purchase orders and we were to deliver the goods within a period of 12 months. Thereafter, purchase orders were issued one after the other. In total, 4 purchase orders were issued, starting from page
101.
101, Your Lordship.
Yes.
The first purchase order is at page 101, dated 11 September 2023. Second purchase order is at page 104, dated 26 October 2023. Third is at page 117, dated 7th May 2024.
Yes, then what happened?
Your Lordship, the railway was to give a particular period to allow us to supply the goods. That period was not given to us, and thereafter they have already deducted 1,55,958 and 8,18,000.
What do you mean to say that time is not mentioned? Page 101, I can see commencement date and completion date are mentioned.
The tender document was issued on 25th August 2022. Thereafter, the letter of acceptance was issued on 31st January 2023, and the first purchase order was issued on 11 September 2023. They were sitting tight for over 8 months. There was
the delivery schedule as appearing in page 101 mentions a delivery. Did you find the delivery schedule? Page 101?
Yes, Your Lordship.
Where is it? In the middle. See, there is a box. Comments. Can you see? Did you find out?
Yes, Your Lordship.
11th of September 23 and completion is 11th of September 2024.
Yes, Your Lordship.
1 year time you had.
In between, other purchase orders were also issued, Your Lordship.
Yes.
In terms of that, Your Lordship,
what is your prayer?
Liquidated damages have been imposed
for not delivering
the
the
goods
stipulated time period.
Yes, Your Lordship.
Right.
And my case is that not enough time was given, Your Lordship.
What enough time? 1 year time was given to you. Not ready.
Your Lordship, if it can be kept tomorrow, Your Lordship.
Tomorrow it cannot be kept.
Your Lordship.
None represents the respondents. Let further notice be issued. Released on 23rd of June. Yes, 10.
My Lordship, be kind enough to turn to page 70. Your name, Amara, Prokar. But this is the scheme which is impugned before this honorable court.
Page 70?
70.
Yes.
May I place it, Lord?
Yes, please.
The governor is pleased to introduce the following scheme to provide, kindly underline this, limited livelihood, support and social security on humanitarian grounds on purely temporary basis, subject to consequential orders of any competent court, to distressed families of non-teaching staff in Group C and Group D categories who were recruited through 2016 selection process conducted by the West Bengal School Service Commission, and who have lost their jobs and whose salaries have been discontinued for reasons beyond their control as a consequence of court proceedings which are yet to attain finality, as on the date and where review petitions are pending before the Honorable Supreme Court. Now, this presumption is absolutely preposterous. Then, whereas the state government along with the West Bengal Central School Service Commission have already filed respective review petitions before the Honorable Supreme Court seeking review of inter alia the judgment and order dated 3rd April 2025 passed in civil appeal number so-and-so, with which appointments of Group C, Group D itself staff made pursuant to the 26th recruitment process were set aside. But these were set aside on the ground of the corruption. Whereas by reason of the said judgment, several thousand persons have been rendered jobless overnight, affecting their right to life and livelihood. And whereas the Constitution envisages the state to be welfare state, where preservation of life of every citizen, every person, especially where it has been jeopardized due to reasons beyond their control, is essential for the welfare of the society. And whereas Article 21 of the Constitution of India enshrines right to life as a fundamental right, the obligation to protect which squarely rests with the state, especially in case of matters of public employment, and Article 41 of the Constitution of India also enjoins upon the state, within the limits of its economic capacity and development, to inter alia provide public assistance in cases of unemployment or old age or sickness and disablement, or in other cases undeserved one. And whereas it's a matter of record that Group C, Group D staff were employed under the state and whose employment has now been terminated by an order of court where the state was a party. And whereas the duty of the state to take appropriate measures to ensure that such persons are not deprived of the right to preservation of life overnight, and that such persons have a minimal amount of time to make a suitable alternative arrangements to ensure their livelihood. And whereas it has been done by the state in the past on temporary basis and subject to any consequential order as may be passed by competent court of law, state has formed an opinion to provide support to enable such persons to apply for alternative means of livelihood within a minimal amount of time, and therefore the scheme herein below is formed. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families or non-teaching staff in Group C and Group D categories until the final adjudication of the review petition of appropriate application filed with the Honorable Supreme Court, or any further petition as may be filed in accordance with law until proceedings attain finality. But the basic perception of law is not vitiated. Filing review does not disturb the finality which has been delivered by the judgment. Now, therefore, in exercise of powers under Article 162 of the Constitution of India, Governor is pleased to frame this scheme. What the distressed families? And this will come into effect from 1st April 2025. Distressed family means the immediate family of any non-teaching staff in Group C or Group D category who was recruited through the 2016 selection process conducted by the West Bengal Central Service Commission, constituted under so-and-so. I am not troubling my lord with that. Then kindly come to the next page. Registration to avail benefits under this scheme, and eligible non-teaching staff in Group C or Group D category who belonging to a distressed family must supply application, this and that. Then benefits of the scheme. An eligible non-teaching staff in Group C and Group D category belonging to a distressed family shall be entitled to receive cash assistance of 25,000 and 20,000 per month, respectively, as livelihood support. The benefit shall be discontinued upon occurrence of any of the following events: on death of the applicant, on the date on which the applicant attains the age of superannuation, the finality to the illegal appointments. Upon the proceedings before the Supreme Court arising out of civil so-and-so attain finality through final disposal of the review petitions, or any other further petitions as may be filed in accordance with law by the Supreme Court of India, which was earlier, due to any other provision laid down in this scheme by the state government from time to time. This is the scheme. This will wholly without jurisdiction and will to support the corruption which was perpetrated by the state itself. Kindly come to know. Kindly come to the Honorable Supreme Court judgment. That we have annexed that.
Paragraph 45.
Kindly turn to page 62. Page 63. This is the conclusion of the Honorable Supreme Court judgments. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the court that services of tainted candidates who were appointed must be terminated, and they should be required to refund any salaries, payments received. Since their appointments were a result of fraud, this amounts to cheating. Therefore, we say no justification to alter the direction. The final direction of the Honorable Supreme Court is the tainted service goes and you have to return the money. Keeping this in mind, state government now engages them to support them out of the public fund. Then 46. For candidates not specifically found to be tainted, the entire selection process had been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Further, no candidate can be appointed once the entire examination process results have been declared void. Now, these are the two important directions. The rest are not very important. And then kindly come to page paragraph 51 at page 65. Our observations and findings would not influence the criminal proceedings. Accordingly, we uphold the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in the directions issued by the High Court. The appeals are disposed of. Now, thereafter, the state government, my lord, through its agencies, filed an application before the Honorable Supreme Court. Kindly turn to page 66. The application the application the application they filed an application. Application we are inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9 and 10 and class 11, 12, not found to be tainted subject to the following condition. Kindly see, this is the application made by the state after the Supreme Court judgment was delivered. An advertisement for fresh recruitment to the aforesaid shall be published before 31st May. The examination of the entire recruitment process shall be completed by 31st December. The state government, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May. Enclosing there is a copy of the advertisement for the fresh recruitment as well as the schedule thereof so far as to ensure completion of the recruitment process. The next part is very important. We clarify that this order shall not be read as a conferring any special right or advantage on the aforesaid teachers insofar as the fresh recruitment is concerned. We are not inclined to accept the prayer in the present application insofar as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in this age group is substantively high. And secondly, what has prompted us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study should not suffer. Therefore, my lord, on the application by the state itself, my lord, the Honorable Supreme Court was very categorical about Group C and Group D, no concession to them. Now, after this, my lord, this scheme comes. Now, but the basic duty of all the agencies under Article 144 of the Constitution, Lord, she kindly turns to Article 144.
Constitution টা ছিল না এখানে এটা ফেরত দিয়ে দিন Yes.
Civil and judicial authorities to act in aid of the Supreme Court. All authorities, civil and judicial in the territory of India shall act in aid of the Supreme Court. Therefore, the obligation was that the authorities must ensure that the Supreme Court judgment is respected and followed. Here, to subvert the decision of the Supreme Court, the state government uses its power under Article 162. Now, kindly turn to Article 162. Article 162 is the extent of the executive power of state, subject to the provisions of this Constitution. I have placed in Article 144. The executive power of a state shall extend to the matters with respect to which the legislature of state has power to make laws. But what is the power of state to make laws? To unsettle a Supreme Court judgment or even a High Court judgment? Provided that in any matter with respect to which the legislature of the state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution, or by any law made by Parliament upon union or authorities thereof. The 162 also does not empower them to make a scheme to frustrate the judgment of the Supreme Court, where Article 144 makes all the authorities responsible and bound to act in aid of Supreme Court judgment. But another article which might be necessary for consideration, kindly also turn to Article 282. But this point may be taken, but though after 162 is categorically mentioned, this has no application. Miscellaneous financial provisions.
Which article did you mention?
282.
282. Yes.
Expenditure defrayable by the union or state out of its revenues. The union or state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which Parliament or legislature of the state, as the case may be, make laws. Therefore, 282 is an extraordinary power given for immediate expenditure to be made for a public purpose. Now, they did not take recourse to Article 282, they took recourse to Article 162, but the 160 doesn't empower them to prepare a scheme which deliberately and directly wants to wipe out the effect of the Supreme Court judgment. On this premise, I would like to, Lordship intervention and stay of this. Article 41 with directive principle of state policy, that's also does no help to them. Article 41, which mentioned, says right to work, to education and public assistance in certain cases. State shall, within the limits of its economic capacity and development, make effective provisions for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. None of the provisions that empowers, I would repeat, to set at naught a Supreme Court judgment which has declared that the appointments goes because of corruption. Now, this is the first thing.
Would you like to continue? It's already 1:17. I do not have any objection.
Or could I come back tomorrow, my lord, subject to your lordship's?
But then have you given effect to this?
Yes, it has been given effect to, my lord. I believe, my lord, one installment has already been released.
One installment means it's applicable from 1st of April. So April's money has been disbursed.
No. The notification is issued
But I'll come back with better insight. I'll come back with insight.
Applications are to be called for. It has to be scrutinized, screened. There is a screening process. It will take time. How can it be done so soon?
But I'll take, my lord, better instruction and come back, my lord. I don't think that I should make any comment on that.
But then please do not distribute the money.
In that case, I'll come back at 2 o'clock. Otherwise,
application
Dismiss. Yes.
So that before he starts, I have taken his kind leave. May I place? So thereafter, two further applications are moved to the Supreme Court.
All right.
Now, I kindly takes up this the application, the prayer which was made, not by the state but by the affecting parties.
কোন অর্ডার গুলো দেখাচ্ছে?
না ওটা দেখাচ্ছি তুমি
স্যার এই অর্ডারটা দেখাচ্ছি।
Is it in the same appeal?
Same.
All right.
After the judgment was delivered on 3rd April.
Yes.
17th April, the state application where the modification was to the extent that teachers may be allowed till 31st December who are not tainted. Thereafter, another application was filed by some of the candidates who lost their job.
All right.
This was the prayer made and the order was passed by this court. কি ব্যাপার ওটাকে দিয়ে চোখে দাও না
Clarify.
On 23rd of May,
All right.
the Honorable Court passes the order dismissing the application. We find no ground and reasons to entertain these applications purportedly filed for clarification of the judgment and order dated so and so and the connected matters.
All right.
There before, without notice to us, this was notice to us, another application was moved. There also the Honorable Court passed this order.
একই
একই order.
23/5 দুটো কি 23/5
ওই একটা ওই মীনাক্ষী অর্ডার করলো একটা মুকুল ভারতী।
One is on 21st May, one is on the 23rd of May.
Yes. Of different group of
And
different
prayer was
states.
same for permission to file additional documents, facts, clarification, direction for grant of interim relief, permission to file additional documents. All right.
Therefore, the repeated attempt was made before the Honorable Supreme Court. Honorable Supreme Court did not at all entertain these prayers. In that background, this
scheme has been formulated. All right.
Milord, first is, Milord, who are before the court? Milord, please have a look to me at paragraph 2 of the writ petition. Two, 3 and 4. The petitioners state that your petitioners have the requisite qualification for being appointed in Group C and Group D post in any so and so. Then para 3, your petitioner states that the commission published an advertisement for appointment in the post of Group CD. Pursuant to the advertisement, petition number 1 applied for Group C and petition number 2, Group D. And the petitioners participated. Then para 4, the petitioner states that the petitioners were placed in the waiting list. This is very important. And soon thereafter, the petitioner found that there was large scale, etc. First is, Milord, the petitioners, Milord, were not appointed. They were, Milord, waitlisted candidates. Therefore, Milord, any scheme framed for those who have lost their job, Milord, in my very respectful submission, cannot in any way, Milord, prejudice the rights of the petitioners. Because we are before a mandamus court, we are not before, Milord, any public interest litigation court. Milord, this is my first respectful submission. The second submission is, Milord, the waitlisted candidates were also before the Supreme Court. Milord, your Lordship may kindly, Milord, have a look to me at page 29, the relevant portion of the Supreme Court's order. This is the 5th page, Milord, of the Supreme Court's order. Please take the last 3 lines. Other writ petitions were filed subsequently in 2021, seeking individual appointments and alleging illegalities in the 2016 recruitment process. Illustratively, some of the issues raised were, please turn the page, clause number 4 and 6. candidates in the waiting list for Group D post in the panel published on 26/2019 were ignored and a new notification dated etc. has been published, initiating a new recruitment process. And 6 is candidates neither in the merit list nor in the waiting list were appointed and also joined in the school. Then my lord may kindly take, my lord, the later part of the Supreme Court's order, my lord, the internal page 35 at running page 59. Para 36. Apart from so-and-so not returning mirror copies of OMR sheet, other questions arise. In particular, are the significant discrepancies between the marks in the computer software and the data found on the 3 hard disks recovered from so-and-so. Further, Commission did not upload the marks of the candidates while uploading the list of candidates called for interview and included in the panel as the wait list. Marks were only displayed after the High Court's order dated so-and-so mandated disclosure of marks. This omission appears deliberate, likely intended to conceal the marks of candidates on the wait list, raising concerns about the potential data manipulation, etc. So, my lord, the wait list candidates' concerns were also, my lord, projected, canvassed, and, my lord, looked into by the Supreme Court. And finally, my lord, what order has been passed is that this Honorable Court's division bench order was upheld by the Honorable Supreme Court. Therefore, my lord, my respectful submission is, number 1, that, my lord, the wait list candidates, my lord, cannot have any grievance in respect to this scheme.
Yes.
Why? Because, my lord, please take, my lord, para 45, the conclusion of, my lord, the Supreme Court's order, my lord, at running page 63. But whatever, my lord, relief, buffer the Supreme Court gave was all to, my lord, the candidates who got appointment on the basis of merit list, whatever was, my lord, the consideration of the Supreme Court. Finally, my lord, no relief was granted to the waitlisted candidates by the Honorable Supreme Court. Please have a look at paragraph 45, 46, 47, etc. 48, 49, and finally 51, which Mr. Bhattacharjee has placed.
So the locus standi of the petitioners
is number 1. Number 2 is, like a legislation, similarly, my lord, in case of a scheme, my lord, framing of a scheme or enactment of a legislation itself does not give rise to a cause of action for challenging the same. But the cause of action arises only when someone is affected by implementation of the act, scheme, whatever. I give you, lordship, an example. Say 2003 Electricity Act is promulgated. I am agreed by XYZ clauses. Now, my lord, so long, my lord, I don't get aggrieved, take a cause of action. Say I get a disconnection notice in terms of section so-and-so of the Electricity Act. My lord, then and then only, my lord, a cause of action would arise in my favor for moving the court. Therefore, mere framing of a scheme, mere floating of a scheme, or even, my lord, legislation, my lord, does not give rise to a cause of action. A cause of action arises only when, my lord, it is implemented adversely against the person concerned. So, my second point is, no cause of action has arisen, my lord, for the writ petitioners to move before your lordships. But my third point is, but as Mr. Bhattacharjee has placed, my lord, there are some beneficiaries under this scheme. Right or wrong, there are certain beneficiaries. None of the beneficiaries are before your lordship, or they have not been made.
Why will beneficiaries come? Because they are the beneficiaries.
No. I could not explain myself, my lord. What I respectfully submit is, my lord, none of the beneficiaries are respondents in this writ petition.
Respondents.
Yes.
All right.
Therefore, my lord, without
So
the
you want the 25,000
no,
candidates?
they can always be, my lord, impleaded in representative capacity.
All right.
They can always be represented by representative capacity. I mean, impleaded by in representative capacity. But that prayer has not been made. That leave has also not been sought for.
Very well.
Therefore, my lord, the beneficiaries are not before the court. Number 4 is where Article 144 is sought to be, my lord, invoked. Where no dispute that all civil and judicial authorities must act in aid of the Supreme Court. No dispute on the proposition, because the article is explicit in that. Now, my lord, the Supreme Court has considered, because my learned friend's submission is that this scheme is to subvert the Supreme Court's direction, or whatever has been done.
Or frustrate the direction
the
of the
Supreme
court.
Court's order. Or I say, I take it to a larger extent that it violates the Supreme Court order. But what has the Supreme Court, my lord, opined in such a situation? In such a situation, my lord, the Supreme Court has said that a writ petition is not maintainable, and judicial discipline requires that
they should approach the
Supreme Court. Just have a judgment on this, my lord. But this is a case where very short judgment, my lord, where, my lord, some auction was being held, my lord, pursuant to a Supreme Court direction, my lord. A writ petition was filed, and, my lord, the Supreme Court was considering whether, my lord, the High Court should have entertained the writ petition or not. Please take paragraph 4, my lord, a very short judgment. We are rather concerned to note that WP number, etc., has been entertained by the Lucknow bench of the Allahabad High Court. The writ petition is directed against the auction sale of so-and-so, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court noticed in the interim order that auction was being conducted under orders of the court, this court, and that the matter concerning auction of the house was pending in this court. How then a writ petition could be entertained in the High Court is not understandable. Judicial discipline requires the High Court not to entertain any such petition when the proceedings are pending in this court in respect of the subject matter of the case. The parties should have been asked to approach this court. If so advised, the High Court said had no jurisdiction to entertain the writ petition in the fact situation. We need say nothing further on this aspect except to record our displeasure. This order shall be brought to the notice of the High Court. Therefore, my lord, my next obligation is to demonstrate before this court that where the Supreme Court had passed an order, certain ancillary direction, as my learned friend has also placed, has been passed. The review application is pending before the Supreme Court, where the Supreme Court, my lord, will take a call on that, my lord, whatever is the. Now, my lord, when, my lord, the submission is that the Supreme Court's direction is sought to be subverted, or as I have said, I take it to the highest extent that it has been violated. In that case, my lord, the Supreme Court, noting, my lord, Article 144 was of the view that, my lord, it should be left to the Supreme Court, and, my lord, writ petition should not be entertained. Well, there was a development in the matter. The other development in the matter was, my lord, certain persons, but after, my lord, the order of the division bench of this court was upheld by the Supreme Court, my lord, some persons had moved the division bench of our High Court subsequent to the order of the Supreme Court, seeking implementation of, my lord, the directions of the honorable division bench and the Supreme Court, which was ultimately, my lord, upheld by the Supreme Court. Now, my lord, there, my lord, kindly have a look to it what, my lord, our division bench had, my lord, said. This is, of course, my lord, in the contempt jurisdiction. Instead of, my lord, taking a lordship through the order in its entirety, my lord, all the judgments, my lord, on both aspects, my lord, whether to execute or not to execute, contempt, not contempt, etc., my lord, was considered. And finally, my lord, your lordship may kindly come to, my lord, paragraph 47, which is page number 26 of the judgment. This is our division bench. An order passed in the writ jurisdiction is enforced through a contempt proceeding primarily on the principle that non-adherence or non-compliance of the writ issue tends to degrade his dignity and majesty of the court issuing the writ. In the facts and circumstances of the present case, the ultimate writ was issued by the Honorable Supreme Court, and therefore contempt petition would not lie before this court to enforce such an order unless specifically empowered by the Supreme Court to do so akin to Dination KK Supra. Consequently, in the absence of the provisions of the Code of Civil Procedure, to execute an order passed by a writ court, the analogy or the principle that even if the ultimate decree is modified or altered and affirmed by the Supreme Court, the same needs to be executed. Then, Miller, Article 215 is considered by the Honorable Division Bench. Next, kindly take para 50 onwards, where Miller, our Division Bench, Miller, takes notes of the doctrine of merger, Miller, at paragraph 50, 51, and 52. Then para 53, in the facts and circumstances of the present case, there are 3 orders of the Honorable Supreme Court. Subsequent to our judgment dated, etc., etc., Supreme Court dealt with 2 sets of appeal. Then third order is dated so and so, and a miscellaneous application filed in one of the sets of appeals before it. The last order dated 17th April of the Supreme Court contains certain directions, etc. And Millard, the last sentence at para 54, such order also contains a default clause in the case of non-compliance of the directions contained there. So Millard, everything is being monitored by the Supreme Court, and in para 56, in view of the directions contained in the order of 17th April, it would be safe to infer that the Honorable Supreme Court is still in ceasing of non-compliance of the direction. Therefore, Millard, the division bench is also, Millard, is of the view that the Honorable Supreme Court is in ceasing over the matter. Therefore, Millard, assuming for argument's sake, Millard, that the writ petitioners, Millard, have a cause to, Millard, interject, Millard, the framing of the scheme or implementation of the scheme, Millard, my respectful submission is, Millard, when the Supreme Court is in ceasing over the matter, and Millard, even going by, Millard, Article 144 of the Constitution, Millard, but as the Supreme Court said, Millard, in the judgment which I have handed up, Millard, the parties should, Millard, approach the Honorable Supreme Court. And waitlisted candidates were before the Supreme Court. It's not that they were strangers in the Supreme Court proceeding or before the High Court. Therefore, Millard, these are, Millard, primarily, Millard, my submissions, and Millard, no argument has been made that the state is legislatively powerless to frame this scheme. Because 162 says that the executive powers extend to the extent of legislative powers. So no submission has been made that the state is powerless to legislate on this topic. Of course, it cannot be, because Article 41 has been referred to. Rightly or wrongly, it has been referred to, Millard. Therefore, Millard, in the absence of, Millard, any submission that the scheme or the legislation is ex facie unconstitutional, but in my very respectful submission, Millard, it doesn't call for, Millard, any interim order. Millard, provided, Millard, my points of demur are not accepted by the court. Therefore, Millard, in order to, Millard, pray for an interim order, Millard, one has to show that the legislation or the executive order is ex facie unconstitutional. But that no submission has been made. The submission is that Supreme Court order is sought to be bypassed. And when the Supreme Court has taken note of that, that in such a case, the Supreme Court is capable enough to take care of its order to be complied with or violated, or to act in aid or acting divorce aid of the Supreme Court. The Supreme Court will take care of that. And we have two more sentences, my lord. One is, my lord, a number of review applications are pending before the Honorable Supreme Court. And number two is, my lord, the scheme itself is, my lord, interim in nature. But may I place, my lord, those portions? Mr. Bhattacharya has placed those, but please have a look to, my lord, page 70. Please take the last recital at page 71. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families of non-teaching staff in Group C, Group D categories until the final adjudication of the review petitions or appropriate application by the Honorable Supreme Court. Then, my lord, your lordship may kindly take, my lord, the page 72, paragraph 6 of the scheme. First is, my lord, an eligible non-teaching staff in Group C, Group D belonging to a distressed family shall be entitled to, etc., as livelihood support for his or her distressed family due to sudden unemployment and on humanitarian grounds with effect from so and whose salary has been discontinued. The benefit shall be discontinued upon occurrence of so and so. Any of the following, whichever is applicable or occurs earlier. Of which, my lord, item number II is, my lord, conclusion of the Supreme Court proceeding. Yes, and 5 is, my lord, on securing some other livelihood. Therefore, my lord, the scheme itself is, my lord, interim in nature. Scheme refers to the Supreme Court review petition. Scheme again says that it will come to an end once the Supreme Court takes a final call on the review applications or whatever are pending.
Tell me one thing.
Yes.
The amount has been fixed at rupees
20 and 25,
25,000.
yes.
20 and 25,000.
Right.
How did you fix up this figure?
But I think it is for the C, it is.
So the salary amount you've taken as the base rate or something.
But on this, right now, I'm not in a position to assist you.
And how many candidates' jobs were set at naught by the order of the Supreme Court? Who will be the beneficiaries? The figure?
C and D.
And page 71,
yes, ma'am.
The third recital,
yes, ma'am,
mentions about a similar incident in the past.
Yes.
What are such similar incidents in the past where the financial benefit has been granted
Well,
to?
there has been a lot of instances, may not be for relating to employment. To my knowledge, say for example, my lord, puja donations.
No, those are separate.
Yes,
Those
no,
are separate.
these are because 282, my lord, the attention of the court has been drawn to 282. Therefore, my lord, I am saying, my lord, these are all, my lord, come, my lord, under different heads from the consolidated fund, and my lord, different separate account numbers are required to be, my lord, maintained. And there's another judgment where right now, my lord, I don't recall, where, my lord, our High Court has held in regard to the expenditure from the consolidated fund. It is not for a judicial review by a writ court. I'll get that judgment because I was possibly, my lord, addressing the division bench on that. In a PIL, my lord, that was held.
Regarding the
financial expenditure.
Honorarium granted to the
Yeah, very many
Muslim,
was there. Very
to the
many was there.
Muslim priests or something.
Yes, yes, yes.
There is
So-
one order,
Yes, yes.
right? But tell me, So you are not aware as to why this 25,000 has,
25
and
crores
the assistance that you will be giving to these people, will these people give anything in return, or they'll sit at home and they'll earn the money?
Milord, here, Milord, because of, as the scheme says, because of sudden loss of livelihood.
That means somebody will stay at home and you will go on paying the money till the Supreme Court decides an issue. And how long will the issue be said to be pending before a Supreme Court? Because one after another review petitions will come. There will be no end. You cannot stop anybody from filing a review application.
That is for, Milord, the Supreme Court to consider how long, Milord, Supreme Court will entertain.
And no,
Supreme Court will
your
not
petition
entertain me
says, no, your petition says it will continue till the matter is pending.
No, still, Milord, this review applications, Milord.
So one after another review applications will come.
No, Milord, please have a look to Milord.
Second paragraph, filed review petitions before the Supreme Court. Central School Service Commission has filed review petition. Right.
No, it's only, Milord, the state government, the first recital. Please have a look at page 70.
Yes.
The state government, along with the School Service Commission, has filed respective review petitions before the Supreme Court.
Yes.
Yes. So it is only, Milord, the review applications which has been filed by the state and, Milord, commission, which is taken note of in this scheme.
No, but then what will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Yes. Yes.
And to candidates whom the Supreme Court has specifically used the...
May I say this? Yes, I got your Lordship's point. My first response would be, Milord, that, Milord, at the instance of, Milord, the writ petitioners, Milord, with respect, Milord, kindly do not take me amiss. Possibly, Milord, this point cannot be raised by the petitioners. That if I am not getting, why is he getting?
No, he is not getting his waitlisted, no question of it.
Therefore, Milord, if he or the petitioners over here cannot get, then, Milord, the petitioners does not have a cause to pursue before this court.
So you want somebody who were there in the Supreme Court to come here and challenge this? Who could be the, according to you, the challengers to this scheme?
Milord, may I say this, Milord? Today, Milord, we are concerned about the writ petitioners. But if the writ petitioners either have a right or they don't have a right. If they do not have a right, Milord, then whether tomorrow somebody will come or somebody comes at my liking is something different. If they do not have a right today, Milord, in my very respectful submission, Milord, this petition cannot be
maintainable. All right.
Entertained. Because, Milord, your Lordships have held, Milord,
yes,
mandamus is, Milord, for infringement of an established right.
Anything in reply?
No, 1995. 1995. যেটা ও রিলাই করলো
99.
99. Now, the deepest of respect, learned advocate general probably.
The first demurrer was locus standi. It is not a pill, it's a writ petition.
This writ petition by a person who was a candidate. After cancellation of all appointment method, all persons come to the same footing. There you cannot make a classification. That's the first point, Milord, for a writ petitioner, which comes under Article 14. I am not, therefore, the locus standi petitioner, Milord, cannot be questioned at all.
Very well.
Secondly, one important aspect which you wanted to raise kindly takes up 1999 5 SCC. I have not cited judgment, but if necessary, there are judgments, I will cite it. But let me rely on his own judgment, which is relied upon. First of all, this has no 141 application. Kindly first.
144.
No, 1999 5 Supreme Court cases, page 733 does not decide any law which has binding nature to this court under Article 141. What does the court say? Let us see. May I just place it? Paragraph 4. We are rather concerned to note that the writ petition number such and such has been entertained by the Lucknow bench of the Allahabad High Court. That writ petition is directed, kindly see, against an auction sale of house number such and such, and seeks an order to the effect that the auction sale be not confirmed The learned single judge of the High Court has noticed in the interim order that auction was being conducted under the orders of this court, and the matter concerning auction of the house was pending in this court. Therefore, the question of amity of judicial discipline comes. In our case, this is a new cause of action. You prepare a scheme after the judgments have not become a concluded effect. Mere filing of review application does not legally entitle somebody to say that the
list is pending.
Only after the review notices are issued, and the Lordship knows, as so from my experience, I can tell you, Lordship, the Supreme Court review applications are not hard. This is decided by the honorable judges in the chamber. That's why they use this method of filing MA applications, and which have been repeatedly dismissed by the Supreme Court. That indicates the Supreme Court has reached its final conclusion. After that, this scheme, Article 162 does not empower you, I have argued this, to negate a judgment of the Supreme Court in any manner. The judgment declared by a court can only be changed by way of a legislation removing the foundation of the judgment. That is the settled principle. I don't have to argue. Even in this court, we had got the Cooperative Societies Act ultra vires declared. Then they passed a legislation taking out the grounds on which this was declared to be ultra vires and passed another law, which is also under challenge. That's a different thing. Therefore, that is the settled law. Therefore, 162 does not empower you to legislate in the form of executive action to negate a Supreme Court judgment or even negate a High Court judgment. And this scheme is specifically maintained for the persons who have been found to be corruptly appointed. Can the state, in any form, giving in the name of relief, support corruption? This is the first question. The second question was that not only they have been found to be corrupted, this direction of the High Court, which is upheld by the Supreme Court, that they have to return the benefit of money which they have earned so long. And instead of getting the money returned from them, you are trying to support them out of public fund. This is the question of the constitutional morality again comes in. And in this context, Lord, I would like to cite one of the decision of the Supreme Court where the then Chief Minister of UP, Mr. Mayawati,
106.
(106) 2012 8 SCC 106. Here below, the CBI started an investigation saying that the Supreme Court directed. The petition was filed. From that, it went up to the Supreme Court. Supreme Court says entire thing is quashed. Because you cannot take, in the name of Supreme Court, start doing something which is not under the order of the Supreme Court. This is the basic principle of this judgment. I just kindly place before Lordship the relevant portions. 2012 8 SCC, page 106. After discussing everything in detail, now the Supreme Court says 41, kindly come to paragraph 41. We finally conclude that anything beyond the Taj Corridor matter was not the subject matter of reference before the Taj Corridor bench. That is the Supreme Court bench. Since the order dated 18 September 2003 does not contain any specific direction regarding lodging of FIR in the matter of disproportionate assets case against the petitioner, CBI is not justified in proceeding with FIR number so and so. In view of the above discussions, we are satisfied that CBI exceeded its jurisdiction in lodging an FIR in absence of any direction from this court in the order dated so and so or in any subsequent orders, and then ultimately squashed. Here, my lord, I have been facing repeated orders of the Supreme Court saying, no, we are not interfering 3rd April. And by repeated application, as it is also mentioned in the scheme, the review applications filed by the SSC, and in future it might be filed. You are adopting very unfortunate tactics to waste public fund to protect the corrupt people. That everybody has jurisdiction, Milord, and because the Reed Court, where Milord, the fairness of the administrative action, Article 14 is very important.
Page 71.
71, kindly turn to page 71. And my lord has noticed it, that's why he was referring to.
And second last line.
And page 71, whereas the scheme aims to provide interim relief by of livelihood support and social security. Livelihood support, social security under Article 41 does not remain to a particular group. On humanitarian grounds, to the aforesaid distressed families of non-teaching staff in Group C and Group D categories until the final adjudication of the review petition or appropriate application filed before the Supreme Court or any other further petition has been filed. Twice attempt was made. And again, will I say, there is no review application pending for consideration. Mere filing with the registry does not entail consideration by the court. In that background, Lord, I would logically stay the entire scheme. My juniors insisting me just to point out to your lordship paragraph 9
of
the petition, how will his locus is maintained.
Stop.
এই তো আর কিছু তারপর জয় কালী আমি দেখাতে চাইছিলাম আমার লোক কাছে বলে দিলাম তো তারপরে কোন দেখাবো
very well.
But only one factual correction, because in reply, I am not supposed to say anything. Milord, the submission made by Mr. Bhattacharjee that they have to return the salary, but that is, Milord, factually not correct. Kindly have a look to page para 46, page 60, 45 and 46.
Tainted যারা তারা দেবেন
However, Milord, candidates who are already employed need not be asked to refund.
These are for the teachers. The scheme is for non-teaching staff.
না না স্যার এটা বলে দিন
46 does not, Milord, make any distinction between Group C, Group D and teachers.
স্যার not specific.
আরে কোচকে পড়তে দাও না এত ছটফট করো কেন?
Those who are already employed need not be asked to refund.
Yes.
Right. Yes. So you are not giving money to the candidates who are already employed. You are giving money to the candidates who have been terminated.
But my submission is, Mr. Bhattacharjee in reply
yes.
that Supreme Court had directed refund.
Yes.
That, Milord,
but paragraph 45 says
no.
They should be required to refund any salaries received. Then.
But 46, Milord, does not make any distinction between the C, D, or Milord teachers.
Please.
Very well.
Whatever the Supreme Court has said, the Supreme Court has said in the order. Whatever.
But one more thing, Milord.
Yes.
Mr. Bhattacharjee has submitted that filing of a review application does not mean that the Supreme Court is
in CC of the matter.
Number one, Milord, the division bench has said that the Supreme Court is in CC over the matter.
Yes, yes, you
and number two, Milord, there is a judgment of Justice Rumapal. Milord, I don't remember, the page was 555. That's why I remember the page number. Where, Milord, in the context of a contempt application, Milord, our court held that once something is filed in the department, the court or the matter becomes sub judice before the court. Then, Milord, the court may allow it, may dismiss it, whatever it is. But Milord, once it is filed in the department, the matter becomes sub judice. If requirement, I can give that judgment. But over here, Milord, our division bench in the context of this matter has said
that it was correct. That was in respect of limitation of contempt application. That since it is filed, limitation will not run.
Yes, but so yes.
ওইটা ঠিক বলেছো লিমিটেশন ছিল কন্টেম্পটে 1 বছরের মধ্যে অর্ডার ছিল বলে ফাইল করলে পরে
and Milord, salary possibly Milord,
Anyway,
The salary amount was much higher, I am told, than 20,000 or 25.
and that is
So these people will be receiving either 20 or 25 sitting at home.
basic.
With,
Sitting at
but
home.
if tomorrow, the Supreme Court dismisses the review application, matter ends over there.
Till the Supreme Court dismisses, the persons
that
will
is
be paid.
That is expressed in the the
Scheme itself.
Scheme itself. I cannot make any submission contrary to that.
And whether similar type of schemes are extended or thought of by the state in respect of so many unemployed candidates? Only in respect of the candidates orders whose appointments have been set at naught by the
Supreme Court can take care of that, Millard.
No, you are the state. You will take care. Supreme Court is not framing the scheme.
Millard, I have raised, Millard, a legal issue that when it is, Millard, concerning the Supreme Court and in response to the submission.
Yes, I've followed it.
That the Supreme Court's order is being subverted. But my submission is, Millard, it has to go before the Supreme Court.
Hearing concluded, CAV.
I'm grateful.
Affidavit of service is taken on record.
Sorry.
Similar matter. The similar matter is filed, that WPA, my junior mentioned today morning, similar matter.
All right. But
This,
then the locus standi, I do not know whether.
same. They participate in the selection process.
Kindly, this is a very bad practice with respect to my learned friend.
No,
when one matter is moved, after the hearing is concluded, slips are given that similar matters have been filed.
I have no problem.
Are you aware of the writ petition? Not
But it is served, yes. It is.
Very well. It will appear in the list. Give the number.
Decides on this will guide the field.
No, whether they are also similarly placed or not.
Therefore, let them
Tomorrow,
come separately.
it is.
My lord will
ought to
decide
come and
this.
tomorrow, my lord.
Thereafter, my lord,
Yes,
we'll take
it is ought to come in tomorrow, my lord. Keep it tomorrow, my lord.
You give the number.
Yes, I will.
And serve copy upon the
It is
state.
served.
All right.
I just handed over the number. He ought to come tomorrow, my lord. And they participate in this whole proceedings, my lord. Up to Supreme Court. Yes, my lord.
আরে শুক্র বৃহস্পতিবার থাকবে তো
না কালকে তো কাল নেই আমাদেরকে দিয়ে দিলে আমরা চলে যাব আমাদেরকে 31 লক্ষকে দিয়ে
Yes, next one please.
লাভ নেই
11, who is there? Item 11.
क्यों नहीं कोई वाली ना do you have for the petition?
11.
10.
12.
Actually, 11 declared in the petition of the dismissed. 12.
For the petition.
But for the petition, and also kindly turn to page 20. The show cause I am challenging, knowing full well.
For same incident, both.
Why I am before this court? You are kindly sees blood. We had approached this honorable court earlier.
1 minute. Will you represent all the respondents?
72.
Yes.
The case
I got the brief at 10:30 p.m. Today, my lord, one of the respondents, Elawan and other litigation. I have not got the full instruction, my lord. Then my management place, my lord. So for the prior visit, my lord, I shall deal with it. I shall have to take instruction, my lord. And for that, my lord, I need my lord fortnight time.
কতদিন করো না
10 days, my lord, at least.
ইতিমধ্যে একটা নিয়ে যাবে আউট হয়ে গেছে
অর্ডার হয়েছে এখনো কোনো কিছু হয়নি
তাহলে সত্যি কথা
That is their, they have not yet suffered any. Those steps have been taken.
Very well,
They
Milord,
will not-
those steps have been taken, let them not take steps, let them take
No,
instruction.
Your Lordship will not pass any.
No further step, yes.
What is your apprehension?
Milord, my apprehension is that earlier they have asked me that you are not taking materials from the Czechoslovakia, which is your consortium parties.
All
You are
right.
doing it here. We said make it India, make it India policy. Therefore, we are doing it on our own. That was good. We have came before Lordship, challenged it while I was trying to get certain interim order. Now they say, why did you do it in your own? First action was
I am not there. That was with regard to the degradation. This is my lord for department from the
same thing. Punishment.
Separate cause of action.
And the other earlier matter was appearing today is item 72. 72.
Department and your lordship will find page 20.
Both these matters
notice has been so-called notice has been issued on 30th April 25.
That's true.
And today, my lord, 9th June, nothing has happened. Nothing has happened, my lord. Your lordship can be adjourned the matter 10 days.
I don't mind. Let it be adjourned for 10 days. Nothing has happened. Nothing will happen further. It go to
any the relief that has been paid for that amount to one giving final relief to the writ petition. The lordship kindly adjourn the matter for 10 days. I will come back.
Please come.
The item 72 is also with
Can we take up together?
the earlier matter.
On the prayer of the learned advocate representing the respondents to come ready with instruction in the matter, relist the same on 23rd, 2 weeks time. ঠিক আছে? Any steps taken during the pendency of the writ petition shall abide by the result of the same.
Very good. Deep down.
Services. কেউ একজন গ্রেটফুল বললো তারপর
13 Lordship.
Hey,
For not today, Mr. Lordship, and for the state respondent.
Worship কিছু করো নাই।
No, কিছু করেনি।
Who is the petitioner?
Item 12, Milord,
We will be followed.
they have not taken it.
Any coercive action?
Item 12.
Nothing has happened. Your lordship kindly consider.
And learned একটা line লিখে দিন তো, learned advocate appearing for the respondent assures the court
But your
that
lordship
no
will not
coercive
if your
step
lordship
will be taken.
Pass your lordship's order, my lord. I am not
Taken prior to the next date of hearing.
Yes, that's
Only till 23rd.
My lord, I am for the petitioner in item number 13, led by Mr. Ornovo Banerjee. He is coming just, my lord, from court number 8.
What is the matter about?
Matter about renewal of passport, my lord.
Renewal of passport.
Yes, my lord.
All right. And what is the ground for non-renewal?
My lord, one email was forwarded to me from the embassy itself that police verification is not clear. Further, they have instructed me to obtain information from the local PS and local DIB office. I have contacted to them many a times, but no information was provided to me and nothing was given to me. Say they just asking me for some time. I have given time, but they have not replied to me. Thereafter,
All right. Let me hear police verification.
For the state respondent Lordship, that the criminal proceeding was
What is the criminal proceeding that is pending? Is it still pending?
It's pending, Lordship. It's
Where?
It's lodged in May, I think, Lordship. I don't
Which
think-
year?
Lordship?
May which year?
This year.
May?
May, sorry, Lordship. On February, I think there was one complaint was lodged, Lordship. It's in the third para, Lordship. Third para, Lordship. Still pending, Lordship, and we have forwarded the request to the DIB and FRRO. It is also pending. The third para, Lordship.
Finding it.
Proceeding is pending under the Foreigners Act. How can the passport be issued?
This is the first time
There is a
I have
passport
not
there.
having anything.
You do not
Because
know?
Lordship will find it's on 20th February 2025. It was stated that your verification report is not clear.
Right.
After that, there was nothing. This is the first time I'm hearing something from their end.
So
At
you
least
take steps before the competent forum.
we have already mailed, but
No, your mail is not the proper forum.
no,
You
we have
have
already requested them. Lordship, kindly have a look at page 68 for one.
There is a criminal case pending against you, and till such criminal case is pending, the authority will not be in a position to issue any passport in your favor.
But the difficulty is, Lordship, kindly make a direction to that effect.
Which
That
effect?
they should be deciding the issue within a certain period of time.
What issue? It has already been decided. They have said that it cannot be done
But,
during the pen. The law says so.
No, he is outside India at this present moment. He is not in a position to come physically over here until and unless he is handed over the passport. The passport is being given for the extension before the embassy. Until and unless passport is handed over to him and he comes over here for resolving the issue concerned. Kindly, Lordship, appreciate my difficulty.
The address is of here only. He is saying he is reside
Oh,
outside.
he is residing.
Present address is here only. Lordship, it's
Nolhati Birbhum is the address.
Yes.
He's working over there. Is the present. He is working over there. That is
Working
the
over
reason
there
why the
means-
passport is in the embassy of in the Bahrain.
Sorry, I didn't follow you. Where the petitioner stays?
Bahrain. Bahrain.
Where the petitioner stays?
Lordship, he is from Bangladesh, Lordship.
No.
Wife is from Bangladesh.
Bangladesh.
Wife is Bangladesh.
So wife is a separate aspect.
Right.
Separate aspect.
Petitioner's permit cannot be, the passport cannot be given because there is a criminal case pending against him. Yes, who are you appearing? FRRO, yes. Right. Yes. Getting married to the petitioner.
She obtained certain documents, Aadhaar card and voter's ID card. Subsequently, the conditions were there. The petitioner has statement that he had to surrender, get her name deleted from the voter's ID card. Thereafter, the proceedings were initiated against the petitioner, and petitioner is well aware of that. Kindly see case.
This is my writ petition. I have already stated. I have not suppressed anything.
It cannot be done. Please come.
But, at least Lordship, kindly there is steps to be taken in this behalf.
What steps?
I have already applied for the renewal of the passport.
Praise for renewal of his passport. Stop. The respondent authority has not renewed the passport of the petitioner on the ground that there is an adverse police report against him. Stop. Paragraph from the instruction forwarded by the officer in charge, Nolhati Police Station, dated 22nd May 2025. It appears that Nolhati PS case number 72/25, dated 14th February 2025, under sections 336 within bracket 3/336 within bracket 4/340 within bracket 2/318 within bracket 4/49 BNS and 14 of the Foreigners Act is pending against him. Stop. Paragraph. Law does not permit the respondent authority to renew the passport in respect of a resident of India against whom a criminal case is pending. Stop. Paragraph. It will be open for the petitioner to take steps in accordance with law to obtain renewal of the passport. Writ petition stands disposed. Instruction written with the records.
But, if you Lordship, kindly allow me to have a copy of the instructions which has been handed over.
Whatever I have mentioned over here is the instruction. So there is no requirement of forwarding further copy to you.
My lord, I am for the petition.
Yes.
A appearance চাইছে আমার লর্ড, a purported report as per direction of your lordship has been handed over to me. My lord, kindly have a look at that report.
Yes.
Kindly have a look. Report file করেছো?
Previous occasion, your lordship report
Yes.
hasn't.
Lordship, kindly have a look the report. No, no, prior to placing the report, my lord, I am placing, my lord, that I
What is your prayer?
prayer is, my lord, to include my name. Kindly have a look my prayer.
To include your name.
To supply the information which I have made, my lord,
Right.
in respect of my lord
Act.
RTI.
Apply information. Where is the 4th July's application?
My lord,
4th July's application?
4th July application of RTI, my lord.
Yes.
Yes, kindly have a look. And pursuant to that application.
Where is that application? What is the information that you seek?
Page 39, if your lordship kindly have a look.
Applied for mutation.
My lord, then come 42, page 42.
Yes.
It is written by the SPIO to BLLRO, RTI petition such and such, so and so, district.
Any
so-and-so.
reply given?
Request to give the reply directly to the petitioner.
Any reply given?
No reply given.
So
That
why are
is-
you here? There is an appellate forum. 2 appellate forums. Why are you here?
No, my lord, that's appellate forum, my lord, that may be a bar because of the delay.
Delay. So it
Since-
is
since
your
my lord-
delay.
Since
You
my
have
lord, that-
delayed.
No, my lord,
be done?
direction by the SPIO has given.
No,
Then they ought to have. They ought to have. My lord, why I am putting this question? Why the BLRO sat tight over the matter?
Why
Now, in the
that's
contrary,
done? 13th of May, there is already a report and enough details are specified.
yes, lordship,
If you
kindly
are
have a look to the
aggrieved-
report first page.
If you are aggrieved, take steps.
No, my lord, kindly have a look the report.
Hmm.
A search, last paragraph, a search team has already been formed, headed by a revenue officer to find out the hard copy of mutation case number so-and-so, miscellaneous case number so-and-so, through a local order number so-and-so. On so-and-so, the search team has submitted a report stating that the hard copy of the above mentioned case are not available in this office. Why not, my lord? Kindly have a look to my, kindly take trouble my read petition. Then.
Listen, the name of one Akhirul Alam is recorded.
Akhirul Alam is the
not
petitioner.
a party.
No, Akhirul Alam is the petitioner.
No, in that case, the name of Nasiruddin has been recorded.
No, I cannot make him as a party. Kindly see the my read petition. My lord, kindly see page 38. Kindly have a look.
Your case is that the certain plots of land were recorded in the name of some XYZ. Your query was,
is in my favor.
Your query was, how was the name of that other person recorded? This is your query, right? Now, if any order is passed, then the same will be behind the back of that person whose name has been recorded.
No, I am at best, my lord, I can pray before your lordship and prayer A.
Prayer A.
Yes, my lord, at page 9. Or my lord, I made a demand notice that can be, my lord.
What demand notice?
Page 43.
Why don't you approach the tribunal and get an order from there?
No, I cannot because my lord, this is their fault. That is why they said it is not in the computer data. Why? When the mutation case is paid, was
Any
there.
record of rights correction, section 50,
Well,
You
yes,
said
yes.
before
I am not
proper
praying for return
forum.
of rights. I am praying prayer A at page 9. Kindly have a look to that.
Yes.
Let that
prayer A.
info for RTI, SPIO said BLRO
Supply
to supply the
in
information.
respect of his application. August 22, you are delayed. If you continue, stick to prayer A, then I'll dismiss the writ petition. Please come. The petitioner seeks certain information under the Right to Information Act, 2005. Stop. Application under the said act was made by the petitioner in July 2022. Stop. Being aggrieved by the inaction on the part of the authority to provide the subject information, the instant writ petition has been filed by the petitioner in July 2023. Stop. Paragraph. During the course of argument, learned advocate for the respondents has placed on record the report of the Assistant Director and Block Land and Land Reforms Officer, Kaliganj, Nodia, dated 13th of May 2025. The same divulges certain information. Stop. The information may not be enough for the case of the petitioner. Stop. The paragraph, it will be open for the petitioner to approach the competent forum for relief if so advised. The writ petition stands disposed of.
Item number 15.
And my lord, only one line kindly subject to your lordship's correction. My lord, this order will not, my lord, prejudice the other forum. Otherwise, my lord, they say that
What is
otherwise
prejudice?
the other forum may say, my lord, the High Court has not entertained your application.
No, entertain your application.
My lord, it may happen, my lord. I crossed this type of, my lord, situation. That is why I prayed, subject to your lordship's kind consideration. If your lordship so directs, my lord,
it is made clear that the court has not entered into the merits of the prayer of the petitioner. And it will be open for the petitioner to approach the competent forum in accordance with law, if so advised.
Deeply obliged.
My lord, in item number 15, I am for the respondent bank, my lord, in this matter, my lord, I
petitioner.
have filed my affidavit. In the affidavit, my lord, I have already sought for leave to file supplementary
Page
affidavit.
15, item 15. You have filed affidavit.
I am for the petitioner.
Report on affidavit.
Let me hear the
And
petitioner.
my lord, if required, my lord, I may be permitted to file supplementary affidavit.
Why?
I also mentioned because because it is an old matter of 2018. Matter relates to 2018, belated writ petition filed in the year 2023. And some documents were not there at the time of filing the affidavit.
Let me hear.
Only one thing I will explain before your lordship, that it was that matter where the Lok Adalat, where they have approached the bank to pay me certain amount to dispose of the matter. Yes, I have paid on the basis
To account numbers.
my my lord has I got it.
Hmm.
Page 17, I am placing only page 17 before your lordships.
Yes.
This is their application. No, page 17 of the, not the supplementary affidavit.
Page 17 of the
Writ petition.
Yes, page 17 of the writ petition.
That is the application of the bank, my lord.
Yes.
But at the top, my
Two
lord,
account numbers are
two account
mentioned.
number have been placed, and my lord, I am only placing the first paragraph that the opposite party has availed loan from the applicant bank of rupees 1,70,000 plus and the present outstanding in the loan account rupees 1,97,000 and odd and rupees 1,48,817. That was the two accounts that have been placed that we have taken loan. Already from the supplementary affidavit I have showed that your lordship we have already paid 8 lakhs of rupees totally. 1,50,000 is the security amount that is deposited with them. 6,50,000 have been paid in both the accounts. Bank has passed an order just the page before it. Sorry, Lok Adalat has passed the order, my lord, that if they have thereafter they have passed the order that we have paid only against one
and not the other.
Let them go to the bank and then they can pass. Lok Adalat. Lok Adalat will then clarify it. Let them review, make a review application before the Lok Adalat. Lok Adalat will clear it.
Otherwise, they would have to file a writ petition before this honorable court. All on a sudden, they are placing that "Oh, I have not paid the same." It is a poor man.
May I make my submissions? There are two units. One is Joy Matara and one is Bhai Bhai. Not the two units are not together.
Separate.
Different, separate. Bhai Bhai was granted a cash credit facility, and Joy Matara was granted a term loan facility.
Are they represented by same person?
Same person, no doubt. My lord,
Okay.
this cash credit which Bhai Bhai was granted was of 3 lakh, to the tune of 3 lakh. And this
Joy Matara.
Joy Matara was 1.70 lakh. That was the amount granted. My lord, kindly sees page 70, that is our application. My lord, kindly sees first paragraph, the opposite parties has availed loan from the applicant bank to the tune of rupees 1,70,000. So it is only with regard to the term loan and dash, rupees dash. That means it is not pertaining to the cash credit. Only to the term loan which Joy Matara was enjoying, not Bhai Bhai.
Prior to this, paragraph 1,
I'm coming.
let me also understand, at the top, 2 account numbers is mentioned.
2 account numbers are mentioned.
DL.
DL means demand loan, that is term loan.
Term loan. And OD is cash credit.
Overdraft.
Overdraft amount. Right? So this 1,70,000 was in respect of the term loan, DL.
DL.
Why is OD number mentioned over here?
My lord, OD number is mentioned, but no money is mentioned. About.
Yes, there is
My
money
lord,
mentioned.
rupees
At
dash.
para 1.
One minute. Lines number 3 and 4, 2 figures are mentioned.
Figures are mentioned. Now, my lord, I am shown. My lord. Kindly turns to my lord, page 16.
No, page 17 only
17,
you
my
stay.
Yes,
The
that
two
is the outstanding
figures,
we have stated.
1,09,000 and 1,48,000.
48,000 is with regard to the cash credit.
Why are you bringing in cash credit over here if you say that it is restricted only to the term loan?
And then I'm coming. Kindly turns to page 16, my lord.
Yes.
At first mentions Joy Matara Stationery and Bhai Bhai. Both the accounts are mentioned, no doubt. 72,000 was a settled amount, 9,000 was to be paid EMI. And my lord, kindly says awarded portion. Only Joy Matara, no Bhai Bhai. So award was only in respect of Joy Matara.
They should approach before
my
the
lord.
Lok Adalat.
We have clarified that. Well, kindly sees the page.
They cannot.
Which they have impugned, which they have impugned, my lord. The last annexure.
7 lakhs already have been paid by.
We have inadvertently issued one letter prior to this.
Now they are again striking.
Prior to this, a letter was issued saying that yes, you come and collect your no dues. Both the accounts have been settled. We have issued. But immediately on the next date, the controlling branch wrote to the petitioner and clarified the matter in the year 2018, which they are impugning in the year 2023.
But page 19 is there. That bank has said both the accounts you have paid.
Yes, we have done. Inadvertently.
Page 19.
Prior to this.
Page 19 is 14th of December.
Yes.
Page 20 is 15th of December.
Yes.
Immediately they say that it is in respect of only one.
Yes.
See, it is better you go to the Lok Adalat and
Yes,
settle all issues.
Get it reviewed. And I will admit it. Let that be set aside now.
Acha. The instant writ petition arises. No, not arises. The writ petition is in furtherance of order passed by the Lok Adalat held on 14th of July 2018 at Durgapur, Bardhaman by bench number 1 in pre-litigation case number 1034/2018. Paragraph. The petitioner asserts that the award passed by the Lok Adalat has been accepted and payment made in terms of the said award. Stop. According to the petitioner, the said award was passed in respect of two loan accounts being page number 17 এ দেখুন দুটো অ্যাকাউন্ট আছে এদিকে
Were
থেকে
applied
লিখুন।
for by the bank themselves.
As mentioned in the application made by the bank before the Lok Adalat. Learned advocate for the bank submits that though both the account numbers are mentioned in the application, but the award was passed in respect of only one account, within bracket term loan account, and not the overdraft/cash credit account. আচ্ছা ক্যাশ ক্রেডিট কেড়ে নিন, ওডিটাই রাখুন, ওভারড্রাফট প্যারাগ্রাফ। The bank has already issued a no dues certificate in favor of the certificate in favor of certificate in respect of both the loan accounts
Following the said order.
On 14th of December 1998 18 The bank has thereafter, by a communication dated 15th of December 2018, intimated the petitioner that the settlement in the Lok Adalat was in respect of only one account and not the in respect of only one account. Stop. The petitioner is aggrieved by the same. Stop. Paragraph. As the award in question, pursuant to which the no dues certificate was issued by the bank, is কি বললাম?
Is the award in question pursuant to which the no due certificate was issued by the bank
was passed by the Lok Adalat. Accordingly, the parties are relegated to the Lok Adalat for any clarification/modification of the order. Date dated 14th of
15th of December.
15th of
December. That may be.
No, 14th of July.
14th of July.
14th July 2018. Read petition stands disposed.
Only one thing. 15th
Yes.
December, the letter given by them, that may be kept in abeyance or set aside. Because that will remain, then it will a problem.
No, go. Acha. The bank is, however, restrained from taking any coercive step against the petitioner till the issue
is
as of now there is nothing to be decided till the matter is settled by the clarified by the Lok Adalat. Yes, next.
But this 15/12/2018 will remain. That may be.
They will not take any coercive step.
That is the basis of my clarification, my lord.
Yes.
As per earlier direction by your lordship, the respondent obviously in that report they mentioned about
What is your prayer in the writ petition?
yes.
Take the microphone, please.
My lord, I am seeking the deed, mutation order, and other supporting documents of the said land.
Mutation
order, my lord.
For mutation, why have you approached this court?
May I just indicate in short? Practically, the petitioners applied for a copy of the order with respect to a BLLRO mutation of a particular person. Well, there he sought for certain documents. Well, if your lordship kindly takes up page 21. That was the original application. Page 21 of the writ petition. My lord. There the two things has been sought for, my lord, to provide me the copy, order copy of the concerned officer of in BLLRO, Shingur, with respect to a particular case plot number, such and such, and provide me the supporting documents available on record, such as deed copy and against the above question number 1. Now, my lord, what has happened? After that, he has been provided with immediately on the next page, if your lordship kindly sees, the case numbers and all the details has been provided with respect to that mutation case. But so far as the order is concerned, they have been asked that there is a procedure for applying for the same with and has to
Certified
give
copy.
as a certified copy. Some amount of fees is required as per the per pages. Well, that's what exactly the report also reveals. Well, they are saying that as per RTI Act is there, nothing can be inconsistent with that, and therefore we are not liable to pay any fees for that. But this is not in inconsistent with the Act. Our approach is categorically that it is in consonance with the same, but some.
What is your prayer?
My lord, we are asking in page number 23.
Yes.
We are asking the structure about. We don't know how to pay, so we are asking
You
that.
do not know how to pay. What? You do not know.
But they
You are
didn't-
the legal representative of your client. Why don't you advise your client properly as to how to obtain a certified copy? You have filed a writ petition. What is your prayer? You want certified copy?
My lord.
Apply. You'll get it. Do you want anything more?
My lord, we applied in the first appellate authority.
First appellate authority cannot provide you the certified copy. What is your prayer? You want information?
My lord,
What?
about the said land, the
Information has been provided to you. What more do you want?
My lord, we went to first appellate authority.
Again, why will you go to the first appellate authority? Because you have been provided the information. How are you aggrieved by the information that has been provided? Are you aggrieved? Are you aggrieved by the information?
My lord, we need the information, but they didn't provide us the information.
What information you need?
Information about the land. We want to know the details, mutation
Page 22 is the reply to your RTI application. There are 3 case numbers.
My lord.
And you have been requested to apply for the order sheet with the requisite fees.
My lord.
Do it.
My lord, we didn't pay.
Why did you not pay?
The requisite fees. We want to know the structure. So
Page 28 is the reply. My lord.
They replied on after 7 months. My lord, page number 23. We asking the same thing they tell in the report.
By submitting High Court form number 54, they can obtain the certificate copy. Well, that has been authenticated.
They replied after.
Why don't you apply for the certified copy? You will get all details from there.
My lord.
Did you file a report?
My lord, yes.
Yes, I see a report is over here.
And the last page of the report, the last 2 pages, my lord, is about that notification. There is a clear procedure that they have to pay some fees, my lord. That is the only issue, and have to apply in a proper.
The petitioner has sought for certain information under the Right to Information Act 2005. Stop. The revenue officer and the SA, PIO, Office of the Blockland and Land Reforms Officer Shingur Hooghly video communication dated 27th November 2020 provided the information as sought for by the petitioner. Stop. The mutation case numbers were disclosed. Stop. The petitioner was advised to apply for the order sheet of the mutation cases with the requisite fees. Stop. Instead of making application for obtaining certified copy of the mutation cases, the petitioner proceeded to file a first appeal under the RTI Act. The said appeal was disallowed by the appellate authority, granting liberty to the petitioner to apply afresh, seeking the case records. Stop. Any second appeal preferred or what?
No, after that, the writ petition. That is only appeal. There, the only point taken is that one that.
The petitioner has thereafter filed the instant writ petition. Stop. Paragraph. It peruse the report filed by the Blockland and Land Reforms Officer Shingur Hooghly, dated 9th April 2025. Stop. It appears that the
first
authority has only sought for an application from the petitioner along with the requisite fees for providing the certified copy of the documents sought for. Stop. Paragraph. It will be open for the petitioner to make proper application for obtaining certified copy of the documents from the authority, subject to payment of the prescribed fee. Written disposed. Next.
17 I
By
appeal for the state
application
response.
for the purpose of obtaining payments for the works done. Not by tell you lordship will
My
want
lord,
to.
yes, act a second. My lord, before my learned senior friends takes up the matter, my lord. My lord, on the last occasion, I had submitted a report filed by the secretary. My lord, inadvertently, it was my mistake, my lord. The annexures to that report was not furnished before this honorable court. But I have a fresh copy of the entire set. I have already served them. My lord, may I hand over?
Without annexes.
No, sir, annexures diye party. Sir, 8 annexures. My lord, may I have hand over a fresh copy of the report, my lord? Letter copy.
Very well. Let me tell you, lordship, what has happened. There was a work awarded to my client.
No, what happened? You want payment?
Yes.
Why is it not being paid?
Lordship, kindly come straightway. This is the maintenance period. Last 4 months, 6 months payment has not been made. Now, my lord, kindly, that's the report of my land friend also. But if your lordship kindly come to page 17 of my writ petition.
But they have given in the report, I can see there is reasons mentioned for non-payment.
Reasons, very peculiar reasons. It's not that the work has not been done. It's not that the work.
But are the reasons under challenge? The reasons are not under challenge.
Intimated to me.
Now you've got to know.
Lordship, kindly come to page 17. What was their stance at that point of time? Now they are altering it because we have come to the writ application. That was the, if your lordship kindly sees that, that's your
page 17.
Page 17.
Yes.
That's the later of the executive engineer. But may I please for your lordship? The reference above this is to inform you that the package number so-and-so has been completed of DLP, that's a maintenance period, work on 31st March 2022. But last 6 numbers of 5th year's bill has not been paid to the agency named so-and-so due to the systematic error in e-mark system. The all matters have been corresponded with IT nodal officer and NRIDA. They express that the package is completed as a logged out in eMark system, so that it will be paid in offline. That's what their stance at that point of time. Now, kindly see, it's also noted, it's still now pending for payment in PIO logging in the system. This is submitted for kind information seeking permission from your end. That was the stand at that point of 2022. But they did not pay, they did not reply to my subsequent letters. I moved before the lordship that what were they doing, that they are not making payment to us. Now that the secretary of the Panchayat department.
Listen, now since they have disclosed the reason, you have to
If the
challenge
lordship
it.
Now kindly looks at the reason. Very peculiar.
Page 3 of my
State will pay you 4 out of 6 months. 4 will pay you certified, but the 4 have not been paid to me.
Due to recurring late submission and thereby violation of the SDB clause. Same reason for both.
If 4 have been condoned, why not 2? Very peculiar stance taken by them. The government is taking this kind of stand. I could appreciate the very bad work
Has
done.
repeatedly delayed
not
in
completed.
submitting the bills beyond 10 days.
medical
However, the contract has approved the first 4 bills.
Because the chairman was zeal. Medical cert was also given to them. That was the reason that there was some delay in submitting the bill.
12 days.
If your lordship now kindly looks to their paragraph,
What was the due date of submission of the bills?
that was what they have said, according to 10th day of succeeding month. The page 2, paragraph 2, though they have not quoted clause.
Yes, but how many days delay was there?
Kindly see this chart. Lord. Initially there were 13 days, then second was 5 days, then there was 38 days condoned, 7
Oh,
days.
beyond the scheduled time, 12
which have
days.
not been
See,
condoned.
this is not a reason for non-payment.
With
days
regard to
then-
with regard to the state respondents, my lord, the portal was suspended. My lord, the portal was not in function.
It's not concerned. If the work is done,
My lord, we have saying that they are entitled to the bills, but
Then who is
unfortunately,
paying?
my lord, the department, my lord, kindly sees we have correspondent with the Department of the Government of India.
who are you
My lord,
representing?
my lord, I am representing the state. The department,
to
my lord,
pay?
my lord, at the last page of my report,
Who is to pay?
my lord, the National Rural Infrastructure Development Agency, Ministry of Rural Development. My lord, the portal managed by that.
Who is to pay?
I am to pay. The
Pay.
fund comes from that department, but
report is not
ratification
concerned,
comes from
it is
that
for you.
department.
Pay it. How soon?
My lord, we are ready to pay, my lord, subject to what your lordship passes any order.
Immediate payment.
Because, my lord, we are saying that they are entitled to payment. But because of this
payment of
embargo,
the
my lord, we
petitioner-
cannot.
The payment of the petitioner has not been paid. Allegedly, for delayed submission of 2 of the bills. Stop. The first bill was submitted beyond a period of 12 days from the scheduled claim period, and the second bill submitted beyond a period of 3 days from the date, from the scheduled claim period. Stop. The bill amount is rupees 3,59,668 each. Stop. The petitioner was intimated that
প্রতিদিন এই লাস্ট ম্যাটার ধরা হয় এখানে লাস্ট ম্যাটার না এটা ভালো লাগে আর এখন দিন ভালো যাচ্ছে আপনি তো
due to systematic error in choto e marg marg all caps system, the 6th the last 2 bills could not be paid. Stop. The petitioners
Neither 4 have been paid. 6 have not been paid. Not only 2.
last 6 number of the 5th 5 years bill could not be paid. Stop. The respondents admit that the petitioners are entitled to receive the payment. Stop paragraph. The respondents are directed to take immediate steps. Now, এই লাইনটা কাটুন, তার আগে লিখুন, the reason for non-payment of the bills of the petitioner cannot be appreciated by the court. Stop. It is the respondents have admitted that the petitioners would be entitled to the payment and intimated the same to the petitioner way back in 2022. Stop. It is high time that the respondents take steps to clear the outstanding dues of the petitioner. Stop paragraph. Who will be the appropriate authority upon whom the direction can be passed?
But according to the executive India concern, that is the respondent number 3. 3 and 4 anyway. 3.
The repetition.
Repetition. Actually, it should be
the secretary, Panchayat and Rural Development Department is directed to ensure that the payment of the petitioner is positively made by 30th of August 2025. Read petition stands disposed of.
Grateful. No.